Good morning, everyone. Thank you for joining us for the Medical Board of California's quarterly board meeting. While this meeting is being conducted with participating board members and staff from the Nickerson Auditorium in St. Agnes Medical Center in Fresno, California, this meeting is being streamed interactively using WebEx to allow for remote public comment in the same manner as recent meetings. Public comments for those who wish to speak will be heard for each agenda item from individuals attending in person and remotely. To be ready for remote public comment, we ask that you please ensure your comments can be heard clearly by being connected to the audio of this meeting through the proper method. If you're having difficulty hearing the audio of this meeting, it could be because the device you are connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application and then select Switch Audio. You'll see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you've joined the meeting with. By using this method, if you are having audio problems with your device, this will still allow you to participate and hear the audio of the board meeting. Please see View Additional Meeting Information link on the first page of the meeting agenda for more information on connecting to the meeting and accessing meeting materials. Thank you, President Lawson. You can now start the meeting.
Thank you, Sean. Good morning, everyone. I'd like to ask us all to please turn our mobile devices to silent so there are no interruptions during the meeting. For members of the public, you may notice that board members are accessing their laptops, phones, or other devices during the meeting. They are using these devices to access board meeting materials that are in electronic format. If you're a member of the media and require assistance or information, please see Aaron Bone, sitting right here, waving his hand. Thank you, Aaron. This is an official business meeting of the Medical Board of California, and disruptions of the board's business will not be tolerated. Government Code Section 11126.5 allows a board to remove people who willfully interrupt a meeting and to clear the room if order cannot be restored by removing or muting the disruptive people. We will have a designated time on the agenda for public comment on items not on the agenda, and we will ask for public comment on agenda items as well. The board welcomes public comments on any agenda item, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you will be recognized. As Sean mentioned, this meeting is being streamed via WebEx. Individuals attending the meeting remotely via WebEx will also have an opportunity to provide public comment and will be assisted by the host who will be facilitating the WebEx meeting. During each agenda item, the host moderating the WebEx event will activate the hand raising and Q&A features and will ask anyone wishing to make a public comment to indicate so by raising their hand or entering yes in the Q&A window. The host will then call on individuals who indicated they wish to make public comments by the name provided by the individual, which may be a pseudonym. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment, but this time period may be reduced depending on the number of people who wish to speak so that more people may be heard. The host will audibly announce when 30 seconds remain to conclude the public comment. After the individual's time for public comment has lapsed, the individual will be placed back on mute, and only one public comment per agenda item is allowed per attendee. During agenda item 2, public comments on items not on the agenda, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, no further comments will be accepted. During public comment on any other agenda item, 20 minutes will be allowed for each comment period. After 20 minutes, no further comments will be accepted. Each person will be limited to 3 minutes per agenda item. I'd like to remind all speakers to please stay on topic and keep your comments to the allotted time or less. Today's meeting will be run according to the Open Meeting Act as required by law. We plan to end today's meeting by 5 p.m. I would now like to call the meeting to order at 9:06 a.m. Ms. Strother, please call the roll.
Dr. Ayala Rodriguez, Dr. Bolat,
Here.
Ms. Chung,
Sorry, I'm here.
Dr. Helzer,
Here.
Ms. Mitchell,
Here.
Dr. Mahmood,
Yes.
Ms. Rimke,
Here.
Dr. Thorpe,
Here.
Ms. Torres,
Present.
Dr. Sai,
Here.
Mr. Watkins,
Yeah.
Dr. Yip, Ms. Lawson.
Here. Thank you. A quorum is present. I would like to remind the members again that we will be taking a roll call vote on all action items. Moving right along to agenda item 2, public comments on items not on the agenda. And before I ask for public comments, I'd ask individuals making comments to please not discuss pending complaints, pending licensing applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications as they could provide information to the members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and could lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where a decision is still pending. In addition, the board would like to ask the public to please address the board as a whole and not individual members. And please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and decide whether they'd like a future agenda item on this topic. No other action can be taken on the item at this meeting. Though this may seem at times like board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed and to avoid compromising the speaker's goals or the board's mission. If you want to comment on an agenda item, please do wait until we get to that agenda item. Comments at this time are for items that are not on our agenda. Please do limit your comments to 3 minutes. Are there any comments from those present in the hearing room? All right, seeing none. Sean, are there any public comments on WebEx?
Yes, if you'd wish to make a public comment, please use the hand-raising feature. You can type anything into that Q&A window if you'd like. You don't have to type the whole question, just that you'd like to make a public comment. And if you're in a call-in only line, you can press *3. First up here, we have Pat. Pat, you should be receiving that prompt on your end. Good morning, Pat.
Efficiently. Great. Okay, my name is Pat Irving. I'm an RN with over 40 years of healthcare experience. I am currently a member of the National Campaign to Protect People. I'm getting a little feedback. Today, I will be making a comment on the negative impact the National Opioid Settlements Injunctive Relief is having on medical care. It would be my guess that many of you are not aware of the significant harms the settlement injunction is causing to innumerable patients across our nation. And many of you may be wondering why specifically the medical board in California should get involved. Here are some of the most pressing reasons. First, the injunction was written to search for, quote, suspicious physicians, end quote. This definition has nothing to do with the quality of care that the physician is delivering, but whether the physician is prescribing unusual amounts of controlled substances, and that's determined by an algorithm. As far as can be determined, there is not a single clinical person involved anywhere in this decision-making process. Once the algorithm runs, deficient outliers are now in reports for, in quotes, the benefit of the settling state's attorney generals and the DEA, end quote. No search warrant or probable cause is needed. The second reason the board should be involved is that the injunction's restrictions, specifically its limits known as thresholds, are causing shortages of medication for legitimate patients and their respective physicians. Physicians who want their patients to receive a given controlled substance, even a medication for opioid use disorder, may find that their patient cannot obtain the medication. Needless to say, the clinical consequence of this can be life-threatening. Finally, the harm being done to patients is being noticed by the state's largest of healthcare systems, including Kaiser Permanente. In fact, a Kaiser physician commented on this very thing at the board's last quarterly meeting. And this topic has been raised by a leading pharmacist from Kaiser Permanente at the last two board meetings of the pharmacy. So it's not just the patient advocates, but experts such as these that are asking for help addressing the problems that are a direct result of the injunction. In conclusion,
30 seconds
the
remaining.
injunctive relief associated with the national opioid settlement has put unnecessary barriers. Do not be fooled by benign descriptions of the injunction. The only way to truly understand its draconian nature is to read it for yourself. It can easily be found as an exhibit attached to the settlement. Please, I ask you for all our patients, follow up on this issue. Thank you so much.
Thank you for your public comment. Next up here, we have Susanna. Susanna, you should be receiving a prompt on your end. Morning, Susanna.
Hi, can you hear me?
We can. Please go ahead.
Great. Hi, my name is Susanna Zarajski. I'm from Cupertino, California, and I'm the citizen sponsor of Assembly Bill 3119 to add a long COVID class to the continuing education program for medical professionals. I'm here to ask you to add AB 3119 to the legislative agenda at your next meeting. I proposed this bill to former Assembly member Evan Lowe. It passed both the Assembly and the Senate unanimously, and Governor Newsom signed it into law on September 22nd. Most doctors lack the expertise to treat their patients who have long COVID, which is a set of more than 200 symptoms such as brain fog, chronic fatigue, loss of smell and taste, muscle problems, respiratory issues, and more issues that people suffer after getting COVID. After my mild COVID case that lasted about 2 days, I returned to work, but I couldn't focus in meetings. I struggled to speak and I could barely order a coffee because I had forgotten basic words and I had to go on disability leave. My general practitioner referred me to the Stanford Long COVID Clinic, but I was told to wait 5 months for an appointment. I mean, this is ridiculous. I was desperate and I refused to wait that long. I was sleeping 10 to 11 hours a day and I struggled to get out of bed in the morning. I used most of my energy just to search through the state for medical help. There was absolutely no doctor in the Bay Area who would see me. I had to fight to get a telehealth appointment at the UC Davis Long COVID Clinic. One COVID clinic in Los Angeles required that I would go there in person, which meant an 8-hour car trip for a medical appointment. That's absolutely impossible for people who have chronic fatigue. Although there isn't a proven cure yet for everyone who has long COVID, there are some medicines and supplements which have been incredibly powerful and effective. Patients need doctors to guide them to figure out which of these remedies could be beneficial. There are over 400 million people worldwide and 16 million people in the United States with long COVID. Nearly 1/5 of COVID patients are at risk of developing long COVID, and women are twice as likely to get the disease. I'm urging you to add AB 3119 to your next agenda. There's already a long COVID class curriculum available from Project ECHO and the University of California system, so you don't need to create a new class from scratch. And just to be totally open, I have not, I don't get any money from the pharmaceutical companies or any lobbyists. I'm doing this all on my own. I paid for my own trip to Sacramento when I had to testify in the Senate about this bill. Thank you.
Thank you for your public comment. Next up here, we have Eric Andrist. Eric, you should be receiving that prompt.
Hello,
Good morning, Eric.
can you hear me?
We can. Please go ahead.
Good morning, it's Eric Andrus, a patient safety advocate. Many of the new members are not familiar with my stories or my participation here, so I thought I'd recap a bit for them. My partner of 38 years died prematurely due to negligence of a doctor in 2023, and I'm grateful to have a complaint finally move through the system. An odd thing did happen though recently, and without talking about the specifics of my case and put Carrie on alert, one day it appeared on Breeze that the case was complete and that the doctor's license had been revoked. I was able to download the decision and immediately posted it on social media and sent it to a local reporter. But then out of the blue, the status of the case changed from revocation back to accusation, and the decision document disappeared. Clearly, this board had made a mistake, and when I tried to find out what happened, was told that at the last minute the doctor had requested a hearing. Okay, fine, but why did it all appear on Breeze as completed then? Now I've been forced to eat crow and have a reporter wondering why I told him that this doctor had his license revoked when in fact it hadn't. I had been unable to get a response as to exactly what really happened. But going back to why I'm here in the first place, in 2012, my mentally retarded sister Callie, who I cared for full time, was in the hospital with a strangulated bowel. Long story short, the doctor ordered a CT scan, giving her a radioactive beverage at the same time they gave her a drug 7 times stronger than morphine, which knocked her out, causing her to aspirate the radioactive beverage into her lungs, which caused pulmonary edema and sent her into cardiac arrest. The hospital assumed because she was mentally retarded that she was a do not resuscitate and stood around doing nothing to revive her. When they realized they were wrong, they started CPR and did revive her 17 minutes later, but she was already brain dead from the delay and died the next day. I filed a complaint with both the nursing board and the medical board. The nursing board disciplined 2 nurses, the lesser of the evils, but the medical board refused to investigate the doctor and closed the complaint. 4 years later, I went in for hernia surgery myself, and long story short, again, it was bungled 3 times over 3 years. I now live with an irreversible hernia, gastroparesis, and other medical problems from botched surgeries. I filed a medical board complaint against the surgeon, but the board closed it, refusing once again to investigate. Now it was really feeling like retaliation. In 2015, I set out on a mission to start monitoring this board because it was clear that they weren't doing their job to protect us from all bad doctors. It's 10 years later and you're still failing miserably.
30
You've been in
seconds remaining.
existence for over a century and you still can't get it right. Many of you profess that the California Medical Association has no pull over this board, but it's very clear now that's baloney. And many of you are at their bidding to further your public and political careers at the expense of patient safety. What you fail to realize when you all express your frustration with the patient safety advocates is we're here because you're not doing your job. We are a product of this board's lack of protection. Remember that. Thank you.
Thank you for your public comment. Next up here we have Monty Goddard. Monty should be receiving that prompt.
Engineer and an advocate for my wife, who's been an intractable pain patient for over 2.5 decades. I'm a member of the Speakers Bureau, the national campaign to protect people in pain. I endorse my colleague Pat Irving's earlier comments about the frustration to physicians and pharmacists, and more importantly, the harm to patients resulting from the state AG's nationwide settlement with the distributors of controlled substances to pharmacy shelves. I'm disappointed that this settlement's impact to the practice of medicine has yet to be agendized by the medical board. That said, my focus this morning is prompted by the absence on this meeting's agenda of any discussion of the long-awaited aggressive rollout of your July 2023 controlled substances prescribing guidelines. In preparation for my comment today, I researched your archived meeting agendas and YouTube meeting video records. I selected 2 key meetings. First, your February 2022 meeting, at which Stanford University's Dr. Sean Mackey made an outstanding medical board requested presentation on pain management. And second, your May 2023 meeting, where the board unanimously approved your much improved prescribing guidelines. Both of these meetings were very encouraging to the pain patient community, since all board members in attendance were engaged and accepting of the need to improve pain treatment in California. Having participated as an interested party in the guidelines update, I was very optimistic they would achieve their objective of encouraging physicians to prescribe in a way that is effective for their patients, including those patients that don't fall into the normal guidelines. Sadly, to date, they have not. For this, in large part, I blame the lack of the guidelines' aggressive rollout. Despite the board's acknowledgement, this step was key to achieving improved pain treatment in California. This is not the first time I've raised this issue with the board. Each time I do, I sense less and less receptiveness by the board members. Looking at the board membership in February 2022 and May 2023, and comparing it today, I fear I know why. Recognizing Dr. Bolat and Sai had joined the board by May of 2023, when the guidelines were approved, only 5 current board members were on the board throughout the stakeholders process, which produced the July 2023 guidelines. President Lawson, Vice President Helzer, Dr. Mahmood, Mr. Watkins, and the amazing Dr. Thorpe. Therefore, I'm requesting today that the board make viewing in their entirety agenda item number 3 of your February 2022 and agenda item number 10 of your May 23 meetings a requirement for all board members who have joined the board subsequent to these 2 meetings. I'm convinced failure to do so will stifle any future improvement in pain treatment in California. Thank you very much.
Thank you for your public comment. Just a reminder, anyone wishing to make a public comment, if you haven't already, please go ahead and use the raising your hand feature, type something in the Q&A window, or if you're on a call-in only line, you can press *3 to toggle raising your hand. Last up in queue right now we have is Marion Hollingsworth. You should be receiving that prompt. Good morning, Marion.
Okay, there we are. Good morning. My name is Marian Hollingsworth, and I'm a patient safety advocate. I would like the board to redo and update the information on sexual misconduct on the Breeze website for both patients and doctors. The information currently on the website is minimal at best and is in dire need of updating. For example, the only article offered for doctors is from 1996. I suggest that all board members take the time to look at the Ohio Medical Board's new revamped information and guidance videos for both patients and doctors on its website. It's a solid overview covering the rights of patients along with the responsibility of the doctors. You could include on your website the new laws regarding sexual misconduct, such as SB 1448, the patient's right to know, which requires doctors on probation for misconduct to notify their patients. And there's also AB 1636 from 2022, which prohibits doctors from getting their licenses reinstated if they have been revoked or surrendered for sexual misconduct. I believe the new members also need to review the information on sexual misconduct and patient rights, because there have been a number of sexual misconduct cases recently where the doctor received less than the minimum under the board's own disciplinary guidelines. For example, a doctor who was found to have committed misconduct with several patients as well as overprescribing was just given 5 years probation. This is 2 years below the minimum recommended under your own guidelines. Also, on another subject, it's great to see the board hold meetings in the Central Valley and at a more economical place like a hospital. But I can't help but wonder why the board chose this hospital. St. Agnes has a CMS rating of only 1 star and was just slapped with a $100,000 immediate jeopardy citation for preventable patient death. Last year, it had another $125,000 citation for another preventable death. This information is on CalHealth Find, by the way, a government agency, if you're wondering. It doesn't look as if the board it doesn't look good for the board to appear to have a low bar when choosing meeting locations. While we want you to go to something that's more economical, we still have to look at the quality of the place you are. So it's surprising that a 1-star hospital would be your choice. Maybe someone could research location options for future board meetings. Again, please update the sexual misconduct information on your website. It would be beneficial for both patients and doctors. Thank you for your time.
Thank you very much for your public comment. At this time, President Lawson, I don't see any additional requests.
Thank you, Sean. I'll just do a double check as to whether anyone in the room would like to make a public comment. All right, seeing none, we will move on to agenda item 3, which is approval of the minutes from the last board meeting. Just a reminder that the minutes themselves are a summary and a record of the votes, but the full recorded meeting is posted on the board's website. Members, are there any corrections to the November 21st, 22nd board meeting minutes? How about a motion to approve the minutes?
So moved. So moved.
Thank you. It looks like Helzer moved and a second. Mahmood, how about that? Okay. Any public comments from those in the hearing room? Sean, let's open it up online.
Yes, anyone wishing to make a public comment, you can do so by using the hand raising feature. Type something in that Q&A window, or if you're a call-in only user, you can press *3 to toggle raising your hand. First up here, we have a call-in user from the 949. Oh, call-in user, you just toggled your hand back down. If you did want to make a public comment, please hit *3 again. Okay, not seeing that individual return to the queue, and I don't see any requests.
Okay, great. Thanks, Sean. We'll come back to the room, and I'm not seeing anybody anxious to make public comments on this item. So, Ms. Struther, unless there are further comments from board members.
Sorry, Ms. Lawson. Actually,
back.
they
Okay.
came back.
Great.
Call-in user from the 949 should be... let me try this another way, sorry. From the 949, you should be receiving a prompt to press *6 on your line now. That'll actually unmute you. Hello, 949. Are you there?
Yes, can you hear me?
We can. Please go ahead.
Okay, my apologies. I was waiting for the comments for the items not on the agenda. Can I
Yeah, I'll allow it.
make a comment?
Yeah, please go ahead.
Thank you. Good morning, and thank you for the opportunity to speak today. My name is Kirk Pitzak. I'm a patient with incurable conditions that cause chronic severe pain. I wanted to, first off, endorse the comments of Monty Goddard and Pat Anson. I've been dealing with severe pain long before the NBC's 2023 guidelines. I wanted to thank all who were involved in producing those guidelines. This was a first step. Recently, I saw an old press release for California's 2023 guideline. It said, this will make it easier for patients to get the care they need. Well, did it? Unfortunately, it's not making it easier. Rather, it's more difficult than ever to get care, especially if you're someone who needs opioid analgesics. When the guidelines were being developed, part of the commitment made by the board was outreach to physicians. Doctors are either unaware that they have the support of the NBC or they don't trust that they have the support of the NBC. Physicians who treat pain are in short supply. The few who are still practicing are not thinking of how to help patients individualize needs or how to help them gain function in the most effective way. They're still afraid. It is nearly impossible for a patient, especially a legacy patient, to find a physician to treat them at all, let alone on an individualized basis, as the guidelines claim they can. I surveyed every pain practitioner on a large insurance panel, and not one of them was willing to treat a legacy patient on an individualized basis. There's often talk about how California sets trends for the nation. We must set the trend that our medical board supports their doctors treating patients with chronic pain humanely, adequately, and as individuals.
30 seconds remain.
This is still lacking in California. Patients are still facing near impossible obstacles when it comes to the treatment of chronic severe pain, despite the efforts of this board, despite the guidelines, excuse me, and some of the items mentioned by Pat and Monty. This translates to more patient suicides, more patients having adverse events caused by untreated pain, more abandoned patients who may have no alternative to make drastic choices. It continues to rob people of their lives, their hopes, and their ambitions. California patients need practitioners willing to treat them.
Thank you for your public comment. At this time, I don't see any additional question queue.
Thanks, Sean. Well, just a reminder, we took that comment out of order. We're coming back to a roll call vote on the November 21st, 22nd, 2024 board meeting minutes. So unless there are any comments, Ms. Struther, please call the roll on that item.
Dr. Bullock,
Approve, yes.
Ms. Chung,
Yes.
Dr. Helzer,
Yes.
Ms. Mitchell,
Yes.
Dr. Mahmood,
Yes.
Ms. Rimke,
Yes.
Dr. Thorpe,
Yes.
Ms. Torres,
Yes.
Dr. Sy,
Yes.
Mr. Watkins,
Yes.
Dr. Yip,
Yes.
Ms. Lawson.
Yes, thank you. The board meeting minutes are approved. We'll move on to agenda item 4, which is the president's report. And I just have a number of things I wanted to touch on and call to your attention. First, I wanted to thank our hosts here at the St. Agnes Medical Center in Fresno for having us. It really brings the work we do to life to be here in a hospital and, just to have to walk through the halls of the hospital on our way to the meeting here in this wonderful auditorium. So we're grateful to be able to be here, and also grateful to be able to be here in Fresno. This is the second meeting we've had in the past couple of years in California's Central Valley. It's something that, is very important to patients and consumers across California, that we show up and be present in the communities in which they live and work and are treated. And so thank you all for taking the time and making your way to Fresno so that we could be here in their community with them. I also want to acknowledge the impact of the recent wildfires in Pacific Palisades and Altadena on so many in California, including many of our board members and our staff members as well. And also to thank our first responders, including those in the medical community, for all that they do to protect our neighbors and California residents during these tough times. And I also just want us to keep everyone in their thoughts today as we're now facing some torrential rains throughout Southern California that have the opportunity to create yet another crisis or disaster in that region. With respect to certain, medical board, accomplishments or tasks that we've been working on over the past several months, I did want to let you all know that Dr. Helzer and I reviewed all of the non-active committees and task forces that were in our, I guess they were in our handbook, but that we've terminated committees and task forces that are not currently active. And those committees and task forces may be reestablished as necessary. I will say the task force approach we've been using in more recent years versus a standing committee approach has been very effective in accomplishing work and advancing priorities that are important to the board. So I think that we'll continue to stick with that approach. And to the extent a standing committee is necessary, we'll reestablish that at a later time. Just a couple things I wanted to also highlight. You're going to be hearing about them more from our staff, but I think that they are illustrative of the great work that our staff in collaboration with the board members has been doing over the past couple of years. First, you're going to hear more from our executive director about the complainant liaison unit that has now been stood up. It's almost fully staffed, but as you know, that was a part of our sunset review process and legislation that was adopted again a couple of years back. And that's been, not a couple of years back, but more recently. But that's been a long time coming. That was something that the patient advocate community was very interested in seeing us make happen. And we have now made that happen, and it's up and running. And again, you'll hear more from our executive director shortly about the details. But patients are being interviewed and they're being reached out to currently in real time. And so that's an exciting development. You'll also hear from our executive director about the board's financial condition. As you know, we sought a fee increase recently, and we're granted that fee increase. That's a part of the overall picture in terms of our financial condition, where we're doing quite well. But I also just wanted to thank our staff publicly for the hard work they've done, in addition to having additional financial resources, but the hard work they've done to make sure that this organization is running efficiently and effectively. And then lastly, you'll hear from Aaron Bone about the Physician Health and Wellness program and where we're at in terms of finding an author and moving that program forward. Again, something that is a priority, as we talked about at our last board meeting for the board. It's a priority for others as well, and we've been grateful to be able to collaborate with stakeholders over the past couple of months as we work to advance this important legislation. So with that, I'll open it up for any questions anyone may have on the board. Dr. Thorpe.
Not so much a question, Madam President, but just an affirmation. I just want to say I appreciate the executive committee's leadership, and I really feel and the executive staff's leadership. It's been a dramatic shift over the last year and a half, and I think it's been a very positive one. So I'm grateful for that. Thank you.
Thank you, Dr. Thorpe. Any other comments?
Yes, President Lawson, thank you. I too want to echo Dr. Thorpe. And in addition, I really appreciate the fact that you and Dr. Helzer reviewed our prior committees and task force forces and really look to all of us on the board to really think through some of the things that we're hearing and thinking about where we might add some additional opportunities in our section when that comes to staff recommendations. Thank you.
Thank you, Dr. Ballot. Any other comments? Dr. Thorpe, back to you.
I'm sorry. I should have taken the opportunity when I was being so effusive about my compliments. I would like to just, I don't know if this is the right moment, but and speaking of task forces, you know, we did stand up the opioid task force several years ago and came out with an excellent work product. It is troubling to me to hear the comments from the chronic pain community and from the people who are desperate to try to find someone to take care of them. And I know that that's true. I know it's true because it's true in every community. There's we talk about, deserts of nutrition. Well, there is the whole state of California is a desert for people who have chronic pain. It is impossible to get care. It's not, and their options are basically to just stop functioning or to go to the street and try to get medication, which is laced with fentanyl and extremely addictive, and it's just wrong. And there's been an attempt to try to find ways to project this further. It's a gargantuan task, and this is a first step. We're not the only ones that can be helpful, but I am very empathetic with that population of people because I cared for a number of them for many years, and anyway, I just feel bad about it, and I would like to try to find a way to make a difference, but haven't been effective. So
Yeah, it sounds like maybe a meeting of the task force to start, and then you all can bring something back to us at a later board meeting. Maybe our staff can take note of that. Great. Any other comments? Any comments in the room? Public comments? Sean, are there any online?
If anyone would like to make a public comment on this agenda item, please use the hand-raising feature. Type anything into that Q&A box. I don't see any call-in users, but if you are in a call-in only line, please press *3. First up here, we have Eric Andrus. Eric, you should be receiving that prompt.
You hear me?
We can, Eric. Please go ahead.
Christina, it's like you didn't even hear Marion's comment that the hospital you're sitting in has several expensive violations regarding patient deaths, and you're thanking them for letting you be there without addressing a patient safety advocate's comments to the contrary. Are you having the meeting there for free? Consider this a public record request. I'd like documentation showing how much this meeting is costing to be there, including the costs of the local hotels where all the board members and staff are staying. You could have at least commented on what Marion said because it deals with this hospital's lack of patient safety. You do realize that's a priority topic for the board that you're heading? I guess it's appropriate for a board that has such a miserable record in disciplining doctors to want to be in a hospital penalized for patient deaths by CMS. And the shift that Richard mentioned has certainly made it easier for this board to minimize their efforts in the area of patient safety and ignore the public more. Where's our patient advocate meeting that we were supposed to have this time around? So it's no wonder he likes the change. Thank you.
Thank you for your public comment. At this time, I don't see any additional requests.
All right, thanks, Sean. Bringing it back to the board, unless there are further comments, we will move on to agenda item 5, which is board member communications with interested parties. As a reminder, this is an opportunity to disclose any communications with interested parties relating to agenda items. Do any members have any communications to report? Mr. Watkins.
Yes, I've been speaking to most of the patient advocates, and it was with regard to our proposal that I'll present on Friday. I also spoke to the NBCLA, sat down for a meeting, on-air meeting, where I'm basically garnering support for that initiative.
Thank you. Other communications, Dr. Hauser?
Thank you. I received some written comments in support of the Physician Health Wellness Program, which I forwarded to executive staff.
Thank you. Any others, Dr. Mahmood?
Yeah, I had few inquiries and I directed them to the board.
Yeah, thank you.
I'm sorry.
I think, well, most of us, to the extent we received general inquiries and we forward those on, we don't have to report about all of those. I think a fair number of us receive those relatively routinely. But if there's something specific that's on an agenda item, like Mr. Watkins just talked about, this would be the time. All right, seeing none, we'll open it up for public comment. I don't see anyone jumping up in the room. Sean, is there public comment on the WebEx?
If you'd like to make a public comment, please use the hand raising feature. Type anything in that Q&A window, or if you're in a call-in line, you can press *3. First up here, we have Eric Anderst. Eric, you should be receiving that prompt.
So do none of you in the course between these meetings have any contact with members of the California Medical Association? Wasn't there just a big medical association meeting where the board was represented? Why wasn't that spoken about? It seems to me that the board was presenting some sort of a program there at the medical board meeting, which should have been like less than a day, and the person from the medical board was there for all 3 days. But none of you are talking about ever meeting with the California Medical Association. It seems to me like we hear of stories where the board does meet with the medical association all the time, and then none of you are talking about having special meetings with any of the patient safety advocates. Why is it that you're all meeting with the California Medical Association, but never have special meetings, except for TJ, with members of the public who are patient safety advocates? It's just kind of weird that you have such a good relationship with the California Medical Association and them trying to politically control this board, and yet you won't listen to the members of the public with their cries and pleas for you to stop protecting doctors and stop listening and having your political careers guided by the medical association in lieu of patient safety. That's your job. Why aren't you guys all having meetings like TJ is with members of the public? Why aren't you enforcing having public advocate meetings with the medical board? It's shameful, you guys. It's just shameful that you all sit up there and think you're doing your jobs on this board, and you're not doing anything for patient by meeting with the patient safety advocates. Do you really all go home at the end of the meetings and think you're doing a good job when you're just all ignoring us all? Jeez, never mind. Thanks.
Thank you for your public comment. This time I do not see additional requests in queue.
All right, thank you, Sean. We will move on to agenda item 6, which is executive management reports. We will be taking questions and comments after the conclusion of all of the various reports. So over to Sean. I think you're up first. Is that right? Yeah. Great.
All right, thank you all for having us here today. First up, the staffing updates for ISB. Lost another report developer there, planned retirement at the end of the year. Working on refilling that. We have a new help desk position starting tomorrow, another one in background, so that'll help balance some of that stuff out there on that help desk. Still working to fill one more help desk vacancy that's going to be posted here soon. One programmer, and then that report developer. Making do, helping cover different desks as we can. So, infrastructure updates, we have the ongoing project still of doing all of the network maintenance. In addition, now we're helping with the HQIU Rancho Cucamonga to San Bernardino relocation. And then also later on in the end of March, moving the HQIU Valencia office into a temporary location in Chatsworth. So just a little housekeeping there. The iOS application, we're still working on that. In testing, we found that when we would load the application up to the maximum allowable number of licensees, 16 licensees we allow you to follow on there, it would cause the application to kind of lock up if you were following 2 or 3 licenses, you didn't really notice it. But if it had to check 16 licenses over and over, it would cause the user interface to freeze up until it was done checking those 16 licenses. So we're taking the time now to go back, put that all in the background so it happens without the appearance of the application freezing up, and then retesting everything like that. So it's delayed the rollout here a little bit. Pretty confident right now in the testing that we're doing, and so we hope the next month or so here we'll be having that out. But while we're doing that testing, the development's pretty much done there, so that's freed up the programmer to work a lot more on the complaint tracking system. Making a lot of headway there with the ability to pull all the data that we need out of Breeze, and so that part's pretty much done. It's now building the user interface, translating all of the activity codes and short descriptions in Breeze to something more verbose that's useful for a user. And so some of those wireframe mock-ups that we showed, turning it into more like that instead of just the bare information that comes out of Breeze. So making a lot of good progress there with the iOS application again, kind of just in the final testing phases. So really hoping by the May board meeting, might have some basic things, but certainly by the August meeting, I hope to have maybe not a live demo, but at least shots walking you through exactly how it works and seeing what it looks like in our existing website's template look and feel and things like that. So getting some more feedback from you guys there as we put that together. For the DOC system, the Direct Online Certification Submission System, on January 7th, we deployed an update that allows postgraduate training program users now to upload documents on behalf of licensees. So previously, they could only upload documents on behalf of applicants. Now they can do it for licensees. So they can upload their initial license renewal form, their proof of postgraduate training, and it paves the way to add more documents if we need to in the future. I know we've been working with licensing, talking about the potential of adding those more documents there in the future too. So it gives us that functionality. It might be much easier to roll that stuff out. You have the same statistics. I won't bother going over them, but you have the same statistics on applicant documents. You'll have licensing documents next quarter. The Volunteer Physician Registry, update for that was deployed on December 6th. That basically simplifies the registration process. They can all log in using what we call the Ideal interface. It's the same interface they use in Breeze to do their surveys and to do their wallet cards and things like that. So it's just more familiar to the licensees, one less username and password they have to remember to be part of that Volunteer Physician Registry. So we saw a large jump almost immediately of people going there, and we think some of that's us reaching out to the current volunteers and letting them know that those changes have been out there. But we saw, I believe it was 111 new people register there in just the first couple of days, bringing the total up to 900 active volunteers. So, and I know our PIO office is going to be putting articles in the newsletters and annual reports and things like that to draw more people there. And I'm sure with the wildfires and everything like that, it's making that more front and center. But modernize that application so it should be around for a long time still. On January 1st, 2025, we updated the HCI survey application to require an NPI number if you have one as a licensee. The option of stating that you do not possess an NPI is still there, but if you do say that you have one, now that text box makes it required to provide it. That information will be shared with HCI, and they'll do statistical analysis of it. The wallet card license generator update there is just for informational purposes, just more and more people generating wallet cards. The Breeze Online Complaint Form Redesign project, we're looking at the code dropping, the custom code that's been developed by the vendor finally being added to the Breeze product. So now we can configure it to make it work for us. So early here in March, that code will be available. We'll be meeting with the Department of Consumer Affairs Breeze team in order to get that configured to have those things like the involved parties when you enter in patient information, things like that. It all gets put right into Breeze right where it needs to be. It takes a lot of the setup time off of the enforcement analysts so they can get back to processing complaints, things like that. A lot of the questions will be streamlined on that complaint form to remove some of the non-essential questions to the medical board, things that were there from the initial Breeze release, getting it all cleaned up and stuff like that. So it'll happen in phases, not all in one big release, but we should see things monthly starting to come in the Breeze. And so by the next meeting, I'll present exactly what those things are, just so you all are aware of them. But yeah, excited to finally get that going. And then a new section here, and I'm not going to steal a lot of Doug's thunder on this one, but the project to convert all of the Breeze renewal notices to electronic only. So we will do away with doing paper notices. And so what I've included in that packet, and what I'll keep including in that packet for you, is a couple graphs and charts that show the number of people that we have currently that renew online. And so historically, for the last several years, it's been hovering around 85% of people renew online, and that's end to end. More than that, start the renewal online, but because of a deficiency or something like that, they may still have to talk to a person, mail something in, do something to where it's not just an online simple renewal. So, but 85% never have to contact us, just get it done online. We're hoping that number goes up, but that's probably around some sort of a theoretical limit of, in terms of people getting everything right on the renewals and things like that the first go around. But if we get it to 90, I'd be happy with that. The more interesting number is that last chart that shows several different colors. I believe red is the individuals that renew more than 120 days in advance. So if they currently renew more than 120 days in advance, we do not send them any paper. Their paper renewal notice anyways doesn't get generated to 120 days prior to their expiration. So in this project, we're looking at sending them more frequent email notices and not sending that paper. But over the course of the next 2 years, we'll still send that paper to let them know that we're not sending you any more paper. This will be, instead of a big renewal packet, now you're just getting a letter saying, go online and renew, and this is the last time you'll be notified, so please make sure you have your email address up to date with us. And so we're really stressing to all licensees, keep that email address updated, because that's how you're going to get these notifications from us. I'm sure Doug will have more to share on that. But if you look at that little red part of the chart as opposed to the other three colors there, you can see it's about half and half. Half of them do it prior to the 120 days, the other half in the other successive buckets and stuff. So we're looking to get that 50% up higher, just so people renew earlier, and things like that. But again, after this kind of 2-year phase of rolling out and notifying people we're not going to be sending renewal notices, it doesn't matter when they really renew, it's just as long as they renew online. That'll be the most important part. So just some statistics for your enjoyment there. So with that, I think I'll turn it over to Doug, and I'll go back to my laptop over there in case we have anyone else calling in.
Thanks, Sean. All right, moving on to the licensing program summary. Morning.
All right, pretty. All right, good morning. Update on the licensing program. So in Q2 of fiscal year 24-25, the board received 1,438 initial license applications. That breaks down to 1,185 physician and surgeons, 185 transition, and 68 postgraduate training licenses. We also issued 1,493 licenses during that quarter. Another goal we had is the licensing program met with the Department of Consumer Affairs to develop a comprehensive plan aimed at assisting the program and updating its procedure manual with the goal to enhance operational efficiency and ensure that the licensing processes align with current standards and best practices to assist staff. The board staff is also continuing its efforts to scan and shred stored items per our updated retention schedule. The scanning and shredding these files rather than submitting to the State Records Center will reduce the need for physical storage, ultimately saving the board on storage cost and minimizing the ongoing expense of managing and maintaining physical records. The licensing program focused on applications from applicants during the last quarter who needed a license by December 31st, 2024. By prioritizing these applications, the licensing program minimized interruptions in clinical work and patient care. In anticipation of the legislative changes that occurred on January 1st, 2025, the licensing program updated our website, applications, forms, all to align with the revised laws. Additionally, the board ensured stakeholders were informed of new laws through targeted outreach and emailed communications. We had a forms update. We updated our postgraduate training license enrollment form with the following changes. We added language to indicate that the postgraduate training license will be valid for only 36 months. The research question was removed. since the board no longer needs research information when applicants are applying for a PTL. The fellowship category was added as a program type. And we also added language on the licensing application under the practice impairment or limitation section and condensed the 3 questions into one detailed question. Webmaster Licensing Program responded to 2,750 emails from the licensing webmaster in quarter 2. The most responded topics during this quarter were license updates, continuing medical education, and fictitious name permit questions. For outreach in quarter 2, the board's licensing staff and management conducted an outreach event in which the board was invited to present at the annual California Medical Association. The 3-day event was a great success, and we were informed we would be invited back next year. And for our consumer information unit, in quarter 2, they received 13,773 calls with an average wait time of 4 minutes. 3 of the topics most responded to in CIU during this quarter were complaint questions, renewal assistance, and application questions. And that's the update from licensing.
Thank you, Mr. Hawk. I think we are moving on from licensing now to enforcement. Charlene Smith. Good morning and welcome. We're grateful to have you in this new role for you.
Thank you. Good morning. I'm excited as well. Nice to meet you all. I look forward to serving in this role. I appreciate the opportunity. Look forward to working and meeting with you all. I have been at this board for nearly 24 years. I've worked in both the licensing and the enforcement division. Most recently, I served as the enforcement program manager over the board's central complaint unit. So thank you for please ignore my nerves. So you all have your
Don't
packet.
be nervous. We're glad to have you here.
You have your packets with the information and stats. I'm just going to cover some of the enforcement units. So in Central Complaint Unit, as of January 28th report, we have received 4,449 complaints this fiscal year. The average complaint processing time is 158 days. With the onboarding and the standing up of the complainant liaison unit, we identified some letters that would need to, be implemented as that workflow changes. So we have created letters to inform those consumers of the referral of their complaints to the complainant liaison unit. And that'll be a continual process. Of course, we'll find as we go along if we need to tweak or add any additional. Our complainant liaison unit, we do currently have 6 analysts that are in the unit. The manager will be starting later this month on the 24th. And we have advertised we have 2 bilingual positions, and those have been advertised, so we'll be going through that process to bring those on board. Ms. Jones previously reported at the November board meeting that the complainant liaison unit staff would be going through some thorough training to learn all aspects of the enforcement program, which is very, it's a lot of moving parts. So I'm happy to report that training has been completed. Of course, that'll be ongoing, and as changes come about, we'll address those. So to date, we have referred approximately 116 cases to the complainant liaison unit. Some of those are pending as far as the staff, as they're learning their new duties and coming on board, reviewing those files to get familiar with them and to determine next steps. They have also conducted approximately 19 interviews with consumers who those complaints have been referred to the complainant liaison unit. We are still continuing with the expert reviewer program to try to recruit and renew our contracts for our expert reviewers. We have our focused specialties, of course, but we're always trying to work and bring on, renew the contracts of the current reviewers and look for new additions for those specialties as well. Our probation unit for the second quarter, 33 licensees were placed on probation, and 2 probationary licenses were issued. 6 probationers surrendered while on probation, and as of January 6th, there are currently 573 licensees on probation. Our complainant investigation office, our non-sworn unit, since between October and December, transmitted 25 cases to the Attorney General's office for various, medical malpractice or criminal convictions, vaccination exemptions. So I welcome you. If you have any questions, I'd be happy to address.
Thank you. We're glad to have you on board. We'll hold questions until Mr. Varghese is done with his presentation, which is up next. But to the extent anyone has any questions or wants to make comments, write them down so we can pepper our staff with great questions. Mr. Varghese.
Thank you, Madam President. I will start off my report by saying that the staff, as usual, have regular contacts with our board leadership and other board members on various topics. Also, staff met on a regular basis with many organizations on various topics, and list of those organizations and meeting topics are listed below. So I just want to move on to some important matters like staffing updates. I'm not going to repeat what Shar already mentioned about the CLU unit staffing, but at the end of the 2024, as of December, we were at 14.28 vacancy rate. If you remember, the last report was over 16-17%, but we were able to bring it down with the hiring of staff in the CLU unit, and we are continue to recruit for other positions and promoting internal promotions for staff if they are available and eligible. We try to promote from within and try to hire new staff, new talent from external source. Moving on to the budget update, which I wanted to take some time to highlight certain things, like President Lawson mentioned in her initial President's report. Per estimate as of November 30th, 2024, that is fiscal month 5, we are projected to end this financial year with an estimated budget surplus of between 3.5 and 4% budget surplus. But from about, as you all know, from about fiscal year 21-25, 21-22, this board was operating with borrowed funds or loans in the total amount of $24 million. Of that, we already repaid $10 million and anticipate to repay the remaining $14 million with interest by end of this fiscal year. As per the published budget for this fiscal year, we estimated to take another loan in the amount of $27 million, but I'm very happy to report that if we maintain the current trajectory of the fiscal control, we may only need a smaller loan or eliminate the loan requirement completely. This is a major noteworthy achievement we attained. Credit for this moment of triumph goes to the team of dedicated MBC staff with a strong resolve to process improvement throughout the organization. Also, I need to acknowledge HQIU and the AG's office for them joining MBC shoulder to shoulder in finding savings and expenditure reduction. Legislators and the governor for trusting our ability to be good stewards of our funds and operations and approve our fee increase ask. All of you board members advocating for changes and supporting your staff at MBC. The profession for their support with our sunset ask and fee increase. And finally, but not the least, the public advocates who stood steadfast in their continued support and partnership in our effort to improve our fiscal position and protection of citizens of California. Moving on to also report that since my last report, we published one newsletter and emailed licensees on various matters, including informing them of volunteer opportunities with recovery efforts of those impacted by the South Cal fires, law changes, etc. Also, executive staff met with Consumer Watchdog and Consumer Protection Policy Center, CPPC, discussing various topics. That's also on December 16, 2024, the board was recognized by Dr. Lorna Breen Heroes Foundation as a 2024 Wellbeing First Champion due to the lack of intrusive mental health questions on the board's licensing applications. And this is, I believe, the third time we are receiving this honor. And I will draw your attention to two reports mainly, that is in your notebook, BRD 6D, starting with BRD 6D4. And this is the fund condition report that was included in the governor's budget. And as of November, end of November, you would notice that the $27 million loan that was projected to or proposed to for this fiscal year is still there on this report, with also showing the $8 million and the $6 million loan that we took in the previous year's repayment this fiscal year, and also shows part payment of the $27 million. It shows that like the $4.8 million in the next fiscal budget year and going forward. And even with that condition, you will see the month's reserve at the bottom. It's in the positive range. But what really I want to draw your attention to the next report that's on BRD 6D5. This report, there's no $27 million loan in this fiscal year. However, we are still estimating to repay that $8 and $6 million with interest. And of course, that impacted the bottom line of the months in reserve, but it's still in the positive range, and it shows an increase over the next few fiscal years. And then the next report is the expenditure projection report as of fiscal month 5. And this is line item budget, and at the bottom of that report, you will see that we are projecting a surplus of 3.43%. But this is my prepared remarks about this part of the agenda, and I'll be happy, and my team will be happy to answer any questions. Thank you.
Thank you very much. Are there any questions or comments from the members? All right, Dr. Thorpe, we'll start with you.
I think this deserves a standing ovation, actually. And I'm serious. I mean, I'm. That's it.
Thank you. Other comments, Dr. Yip?
Thank you. We still have room to improve, but it's good start. And first of all, I really appreciate the new board member. So far, 2 meetings. I'm very impressed by the commitment. Second question for Sean, maybe some of the enforcement staff. When we set up the tracking the company tracking system, you work on the software, the platform, and who are the parties that have input on what information, timing, what's the JIT to be put on, like the DAG, the ALJ, I'm sure Excel staff too.
So the complaint tracking system, the involved party meetings that we had, we took a lot of feedback from people there, and have been working with exec and legal on what can be shared publicly through the course of the complaint. But it's all information entered by our analysts, by our HQIU investigators and things like that, get entered into the Breeze system. Various codes and descriptions that we're comfortable with, and then we take those values, translate them into longer, more descriptive things to let the users, the involved parties know what that means in a less internal meaning, more descriptive things and stuff like that. So as these activities are entered and statuses on them are updated and things like that, those items will be extracted and relayed to the user, through the complaint tracking system. I hope that answered your question. Or
yeah, is any plan that before it's finalized, there's opportunity for interest party to look at it, because they're the end user. They're the one to look at where's my complaint. End user means doctors and the public. If I have a complaint, I want to see where I'm at. So I think keep in mind in the future, before it's finalized, say software is one thing, the material is what is important. So that's my point.
Absolutely. Our development timeline was approximately a year, and we started on that just in December of last year. And so our goal is to release that at the end of this year, early next year, somewhere in there, just depending on how much development time we have to split with other projects. But definitely committing to, by the August board meeting, having a demo that we can show. It might not be a live demo, but it'd be screenshots showing you exactly. I know, how it looked. We gave you a very basic wireframe mock-up of how that was in a previous board meeting. How that'll look now, the information will be the same, but how that will look on our website and things like that, to get that feedback. Previous board members had requested colors and infographic-like information in there to show them what could be expected next, what is outstanding, what maybe we're waiting from the complainant themselves to provide, things like that. So definitely along the way we'll be showing those in board meetings, getting that feedback as well from you and the rest of the board members as well too, before we have a final product, again towards the end of the year, early next year is the plan.
And second question is that I know you have a lot of work to do already. I just wonder if the tracking system, when people get a website, they click on it, they search it, at the end, would you have one question, can you rate the experience? What can we do better? Because they're the one they're reading it. I have to say, I actually asked my wife to try it, okay? And she said there's really a lot of room for improvement. Now tonight, I'm going to read about the misconduct, sexual misconduct, just to see how easy I can get it. So I think at the end of every people who get on the site, get one or two questions. How do you rate our website? What can we do better? And that's how we can improve. So.
Absolutely. We have a website survey currently, specific to our website right now. And then we also have, Charlene maybe can give more about this, but we have a end of complaint survey that goes out in closure letters that they can scan a QR code, I believe, and fill out a SurveyMonkey survey about that. But yeah, definitely something to, when the complaint tracking system is launched, some questions specific to what they think about the complaint tracking system, we could definitely incorporate that.
Yeah, great. Thank you. Last question for a new chief enforcement. So I'm sure we hear about the cease practice order for violence probation. I'm not sure we hear 6 probation surrender their license while on probation. Would those information can pass on panel A and B as a routine business, so we know what happened in those cases that we vote on and what happened afterward? Just for learning purpose, so that we can see, are we doing the right job? Are we spending a lot of money on cases that finally end up nothing anyway? So, yeah, thank you.
This part of the enforcement process is new to me, and I'm learning this part because I've been entrenched in the central complaint unit, so the beginning phases. So I really cannot answer your question. Any of the stats we provide are about all of the actions that have been taken. I could not answer if those were through the panel meetings or, other avenues.
Yeah, Carrie has it.
Right. The surrenders, as you may know, are accepted by the executive director. And so the stats that you get at the board meeting do tell you how many surrenders were accepted.
My point is that I would like to know one of those cases. If I warn someone on probation and he or she arranged to surrender, and go back and read my case, would I have done different? Would the DAC have done different? We put a lot of resources come to that point and then end up someone surrender. Would it change the strategy in settlement conference? That's my experience.
So you want a list of who surrendered, so that
right,
you
the cases,
can
at least to the
review it.
different panel that we know when we voted, looking back, what may happen. So, thank you.
I'll speak to that, 'cause yesterday I made that comment. I read through the newsletter every quarter, and then I would see the doctor surrender their license, and the name would look familiar, and I go, that's the same guy or same gal. So I think rather than have us looking meticulously and reading through the back of the newsletter, I think Dr. Yip just wants a summary, and so that includes in our Panel A material that next quarter, these are the members that were in your panel, and they have since surrendered their license. I think just an FYI.
And the reasons.
Thank you.
Other member comments, questions? Mr. Watkins?
Yes, my question is for Sean. I asked a similar question once before about, the current database of licensees that, that we're sending these notices out to for renewal, or, as we kind of walk them or transition them into a paperless space. What is the open rate and the bounce back rate? How do we ever qualify that database?
Yeah, you did ask this question in the past, and the email system that we use to send these blasts out doesn't capture that kind of information like a constant contact would or something like that. It's the system that we have with the Department of Consumer Affairs sends email out. If that email domain sends a bounce back, we get it, but it's a manual tracking process, and honestly, with 160,000 licensees, it's just too much to maintain. What we have switched to in the Breeze platform, I'm going to say mid last year now, is each time you go in and you change your email address in Breeze, it's not just a text box anymore. There's 2 text boxes, but when you fill in both text boxes, it will send you an email as a licensee. It says, you changed your email, please click on this link in this email to confirm you got this email. When they click on that email, then it feeds back into the system now, and it gives us an indicator saying that this person this licensee did click this link, letting us know that at least at that time they received that email at that email address. Now it's on the licensee to keep that email address up to date with us. We did look into the constant contact and those other systems, and at the time they were just prohibitively expensive. But we think that this method of at least knowing how many licensees now have an email that they've confirmed with us, not just a valid looking email, but they've actually clicked and confirmed with us, we can start tracking that information now and work on building that number up. And just keep up with the informational notices to let them know that this is going to be our main way of contacting you. And so it behooves you. I know there's laws and things guiding that they have to provide that with us, or they can actually be cited, I believe, is the kind of stick approach to that. But our goal is to try to build the reliability of that email address as we can, but we do not get any sort of automated feedback from like a marketing company or anything.
Yeah, I think you see when we hear about the pain management guidelines that went out and people are unhappy with the rollout because they were expecting an aggressive rollout. But from our end of it, it was just an email blast. And if the email blast, there's a low confidence or the low open rate, then we're not reaching our target audience, which is these licensees, and that is problematic. So maybe we can petition DCA to have some kind of statistic for us on open rates and bounce back rates so that we can have a better qualified database.
The statistics I shared earlier in my update, specifically the renewal ones, and showing that 50% of those individuals now are renewing prior to 120 days, that at least gives me some confidence that at least 50% of our licensees' emails are getting read and received because they're renewing without getting paper. But yeah, I think at what cost it would be to get those other people as we just keep hammering the point of don't use your work email address for your board license, because when you leave that employer and go to a different employer, you have to call the help desk and get it all changed if you don't have access to that email account anymore. So we're just trying to keep that information out there through campaigns and things like that to let them know, hey, keep an email with us that you're going to keep monitoring, and keep it up to date with us. And we really hope that not only will this switching to all electronic renewals notices save resources and things for the boards, but it also, again, if I know the only way I'm going to get my renewal notice is if I have my email address up to date, I'm going to keep my email address up to date, and I'm going to read emails from the board too. So all part of the campaign, but yeah, it's definitely something we can get some cost estimates for if you guys are really interested.
Thank you. And I just have one question for our new chief. Well, I'm grateful for you. I see we've had 4,000 cases, you mentioned, that ends up at CC, at the Central Complaints Unit. And then 116 was referred to the new liaison unit. I'm just curious, what is the criteria that moves a case from CCU to that liaison unit, because statistically 116 into 4,000 is a very minimal, but I'm expecting when I know the criteria why that filter is so, tight.
So to answer your question, so the statute that established the complainant liaison outlines and it describes it's the quality of care complaints that are within the board's jurisdiction, where we have a patient and complainant information. So also our complainant liaison unit was just stood up in January 2025. So the fiscal year so far, we've received over 4,000 complaints. However, not all of those were received, before the CLU was stood up. And so we are now referring those that meet the criteria of the statute to the complainant liaison unit. I anticipate that number will increase, but it has just been stood up in January.
Right. So I have to refer to the statute for the criteria.
Yes, I don't want to misspeak, but it is,
That's fine.
2220.1, I believe, it provides the definition of the patient representative and the outlines, for example, if we have an anonymous complaint and no patient or complainant information, we have no way to move forward with that. So that in that situation, that would not be referred to the complainant liaison unit.
Yeah, perfect. I'm just, grateful you are here, and
Sure. Thank you. Thank you.
Dr. Willott?
Yeah, thank you very much. You're sitting in the right spot, so you don't have to move back and forth. So welcome and thank you. A couple of the things that, as I'm thinking about the design of how Sean and others are making the process more smooth. In other words, I'm an end user and I want to file the complaint. It would be good, again, for us to look at kind of before the CLU was developed, how were the complaints routed? So, for example, I know I've heard that, sometimes it really should have gone to CDPH or it should have gone to the health plan. It could have gone both ways. But one of the things that I think is really important for us as a board is really understanding under what umbrella does this complaint go to, right? So quality of care issues can be a sticky wicket, of course, right? When we say it so generally, quality of care, well, everything's about the quality of the care that we deliver every single day we see a patient, right? And so that quality of care issue has steps in the way prior to getting to the board, it should be reviewed. And I think that that's one thing that I note, that our patients, maybe our healthcare advocates understand it. And thank you to them for highlighting and helping our community of patients in California to understand insurances. But it's not an easy thing. Can I file a complaint? Can I file a grievance? Do I go to the local hospital? Do I go to the local clinic? So I think that just seeing that process somewhere as a way in which we're defining and helping our healthcare consumers understand. I know we've done it in various ways, but I think that's very important. So it's not just the criteria for referral, but it's even understanding before, upstream from getting to us. Finally, I guess there's a question. You mentioned that you're waiting to hire 2 bilinguals, FTE, staff positions. So the question would be, are we using, and this will be a Sean and you kind of conversation, and Mr. Verghese, how do we address people that are speaking another language? They're speaking Vietnamese, or they're doing sign language. Do we use, now many of our health systems, we use technology that we can plug into so that we can speak our 200 and some different languages in the state of California. Do we have such a process right now, if I were a Vietnamese speaking person?
Yes. Yes, we do. We do have a contract with a service to provide interpretation, and whether on the call or, if we need it, if we received a document, as an example, in a foreign language, we have a contract for that as well. So currently, the 2 bilingual positions are for Spanish-speaking individuals, but yes, we do have a contract available for all the other languages that we utilize. Mm-hmm.
Thank you so
Sure.
much. Appreciate that.
Thank you.
I have one more question, President Lawson, for Sean. I wanted to go back to, I think, what Dr. Yip was asking. And the question is, in the development phase, right, in a systems-based thinking, right, besides the board here, the execs on this board and so on, did we pull together when we were looking at the design of the website, the AG's office, all the other key stakeholders? That's just the question, and maybe President Lawson, it looks like she's going to answer that.
No, I did want to mention, and Sean, maybe, I don't know to what extent you have the details sort of at the tip of your tongue, but there was a tremendous amount of that development. The tracking unit came to the board for those initial stages too, for our input and feedback. So a lot of that work did happen behind the scenes. And then as you're hearing from Sean, they're going to be back to the board with that information as well and sharing it with others to make sure we have that feedback loop that we're getting it right. But Sean, I don't know if you want to talk about.
Oh yeah, we had the
previous
two
work we
interested
did.
parties meetings
Yeah.
where we showed wireframe models, just really basic, what it would look like. But so yeah, the look and feel will change when we incorporate it into our website template and everything else like that. But the idea of here's an activity, it started on this date, it's waiting for something, or it's completed and it was completed on this date, and it's a chronological list of the items that happen with the complaint, along with some of the details to make sure that the complainant knows that we got everything they submitted, things like that.
Thank you. I just want to, I'll try to make my point a little clear. What I'm saying is, or what I'm asking is, I do remember being, and I was on one of those committees, I'm saying, did we bring together the AG's office and everybody? And the answer I heard from our president is yes. That's the yes. That's the affirmative, right?
I'm not aware if they attended those meetings and things like that. The ideas
see.
have all been circulated.
Okay, I'm just thinking of it from a process, right? You bring a lot of diverse opinions through this, and that's my only comment. And I'll let it rest there, and we can move that forward. But I think that's just a really important process point.
The translations of the activities and what they mean to the end user, all that was ran through the AG's office, things like that.
Okay.
But yeah, the idea is that we're taking a software term, an agile approach to this, so that we put something together, we come and show it to you. You say, oh, we like this 80%, but not this 20%. We'll do something about that 20%, and we'll get to a place where hopefully everyone's happy at the end.
Thank you, Sean.
Other comments, questions from members? We exhausted all the members on this side of the dais. Any from over here? All right, quiet on my right side. Let's open it up to members of the public. Anyone in the hearing room who wishes to make a public comment? All right, Sean, let's go to the WebEx for public comments on agenda item 6, executive management reports.
And if you'd like to make a public comment on this agenda item, please use the hand raising feature, type something into that Q&A window, or if you're on a call-in only line, you can press *3. First request here we have is from Michelle. Michelle, you should be receiving that prompt on your end. Morning, Michelle. Looks like your line's open. Are you there?
I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We've requested more than once for the board to give the public a public comment period for each section for the enforcement summary, a separate public comment period for the IT report and licensing. It's difficult for the public to adequately address you on these important issues in just 3 minutes. We hope that you will include the public's input in the complaint form redesign. We recently worked with the Osteopathic Medical Board on another project and ended up providing suggestions that they incorporated in their complaint form update. We are the advocates who talk to future complainants and have fairly good ideas on what effective updates would look like. We hope you keep this offer in consideration. Regarding the consumer complaint tracking system, I agree with Dr. Yip that a separate meeting outside the board's 3-minute public comment is warranted to review the system that was requested by the public and was supported by Dr. Yip. The complaint liaison unit. We are grateful that the board has a unit running. We've had some experience with one of the complainant liaison unit reps and have discovered areas where additional training is needed. One rep's telling a family that they can only speak to the person whose name is on the complaint and felt that it would be messy to speak to another family member who was at the bedside. In addition, the rep also told the family to not send their complaint to that rep. They asked them to send their complaint to the general email receiving area. Thankfully, this family has advocacy support and was guided on how to deal with the complaint liaison unit rep. Most families do not have that kind of support. So please consider training the unit rep to accept a complaint when the family offers one and to be willing to interview or speak to more than one person who is physically present at the bedside of the patient who died. Thank you.
Thank you for your public comment. Next here we have Monique Hines. Monique, you should be receiving that prompt on your end.
I'm from Bakersfield and a volunteer with Consumer Watchdog. We are pleased that the Complaint Liaison Unit is implemented and beginning to help families. We would like to see the following stats in your enforcement update. We would like to see how many families received the required interview, how many families declined, and how many families did not respond to the board. It is important for the public to see this information so that we can all work together to encourage more people to participate. Thank you.
Thank you very much for your public comment. Next here we have Marion Hollingsworth. Marion, you should be receiving that prompt.
Okay, can you hear me?
We can, Marion. Yeah, please go ahead.
Thank you. Good morning. I'm Marion Hollingsworth, Patient Safety Advocate. I have a comment for Mr. Douglas Hawks on his report. On page 2 of his materials, Mr. Hawks mentions that the board licensing staff and management attended the California Medical Association's House of Delegates meeting. This was to give information on the licensing process and to answer questions from applicants. To quote Mr. Hawks, this 3-day event was a great success, and the board was informed it would be invited back next year. I can understand the board offering its information for a 2-hour informative speech followed by talkback questions, but to attend the entire 3-day event smacks of collusion. Seriously, the CMA House of Delegates meeting is for 500 hand-picked members. It's not just a job fair for medical students hoping to apply for a license. According to the CMA, the House of Delegates meeting is a time for serious association concerns, possible changes in bylaws, and bills that affect the medical profession. So for the medical board to spend 3 full days being wined and dined and smooshing with the CMA brass seems rather suspect for an agency that is supposed to favor patient safety. I think it's fine for the board to speak at CMA events, to give information, but to linger and appear to party with them crosses the line. Please be more considerate of your purpose to protect the California consumers when you meet with the CMA. Also, you mentioned shredding files that have apparently been scanned. What files are you shredding? Should that be revealed in the interest of transparency before they're shredded? I hope this will be elaborated on before you start shredding. Thank you so much.
Thank you for your public comment. Next here we have Eric Andrews. Eric, you should be receiving that prompt on your end.
So I find it really hard to believe that the DCA email system can't track email bounce rates. I run several websites on just a normal consumer server and can track that without paying for extra services. This is 2025, not 1984. There's no excuse for archaic internet technology. If DCA wants information, they get it. The paranoid Kim Kirkmeyer subpoenaed my entire Facebook account when she thought an NBC employee was talking to me secretly, which wasn't happening, by the way. But if they want information, they'll get it. So if you want information on emails, tell them you want it and make them get it. Richard wants to give you a standing ovation for getting out of debt and still not having enough money to do your jobs to protect patients from bad doctors. The show he puts on to look like a team player when this board is failing miserably at its job is just comical. He's such a puppet. We all know who you really are, Richard, and where your allegiances are. Has anyone studied how reductions in programs so you can get out of debt affects patient safety? When you don't pay HQIU and others enough money to want to stay with the program, don't all of those money-saving efforts have a negative effect on patient safety efforts? I think they do. When you don't have enough staff, and I'll go further to say enough qualified staff to handle the full amount of consumer complaints that come in, how is it that you can all be so proud of your efforts? You're not even coming close to doing your job properly. This board has been under fire for decades for not protecting consumer properly. So you all need to stop patting yourselves on the back as though you're doing a good job, because you're simply not. You're delusional if you choose to believe that you're not listening to the people affected by your egos and political career paths. When you hit a 50% disciplinary rate, you can start patting yourselves on the back. Until then, it just makes you look arrogant and egotistical. Try humility once in a while, Richard. It's shameful that more of you don't stand up and question why this board is still failing so miserably. Just take a look at the number of complaints that come in against bad doctors and how many disciplines are actually produced. That alone should show you, the new members, that they need to stop listening to the people, trying to manipulate them into being team players, and start doing their appointed job to stand up for consumers of this state and protect us not only from bad doctors, but from all the entities that are enabling the board to protect the bad doctors. There's reasons they want you to stifle you talking to the media, to stakeholders and patient safety advocates, and it's not because people will think it's the board's opinion. There is an agenda item, and if you don't know it now, you'll know it by the time your term ends.
30 seconds
And in
remaining.
the interim, we're watching all of you and the things you say and do and don't do. Don't just take what Carrie and Reggie tell you as truth, because they're not always truthful, especially Carrie. More on that in number 10, where she's trying to abolish Robert's Rules of Order, something that I've caught her lying about not only once, but twice at meetings, saying it's not in the procedures manual. Then why are you trying to take it out, Carrie? Huh? Thank you.
Thank you for your public comment. Next up here, we have Maria Ibarra Navarrete. You should be receiving that prompt on your end.
Maria Ibarra Navarrete. I'm from San Jose. I'm also I am volunteer consumers watchdog. We're very interested in the complaint form redesign and hope that you will consider consulting patient advocates as you work on it. We are the families that file these complaints and use these forms because we have dealt with this firsthand. We had a good idea of what needs to be revised. The Osteopathic Medical Board of California has worked with us consumers, and based on our input has made some changes to its consumer complaint form. We hope that you consider doing the same and want to work with us. Thank you.
Thank you very much for your public comment. Anyone else wishing to make a public comment? Just a reminder, you can do so by raising your hand, typing anything into that Q&A box, or pressing *3 if you're on a call-only line. Last in queue right now is Denise Johnson, but if anyone else would like to make a public comment, please queue up. Denise, you should be receiving that prompt. Good morning, Denise.
Excuse me?
Good morning, your line's open. Please go ahead.
Can you hear me?
Yes, Denise, we can hear you.
Okay. Good morning, board members. My name is Denise Johnson. I'm from Tracy and a volunteer of Consumer Watchdog. We are very interested in the complaint form redesign and hope that you will include patient advocates in this planning as you work on this redesign. These complaint forms are the only tools the public has to use to file their complaints. Families go into this process knowing nothing about the process. Give families the information they need on the complaint form so you in turn will receive the information you need to receive the complaint and begin processing it. Allowing us to provide input into this redesign will save your staff time and will save money. Thank you.
Thank you for your public comment. This time I don't see any additional requests in queue.
Thank you, Sean. We'll bring it back to the board. We'll just double check in the room that there aren't any comments in the hearing room. Any further comments, questions from members? All right, thank you all for the updates. We'll move along to agenda item 7, updates from external stakeholders. And again, we'll take questions and comments after we hear from DCA and HQIU. And first, I can't see on the screen. Is Melissa there from DCA? All right, I'd like to introduce Melissa Gear from the Department of Consumer Affairs. Ms. Gear.
I don't know why I am still upside down.
Um, let's see. Sorry about that. I tried to fix it. Am I upside down? Yeah.
Under under the audio and video menu item up there, you should see video settings. And if you go in there, there should be a video adjustment. I think you can do a rotation there. Or
Let's see.
I think it's acceptable if you want to turn your video off too. It's fine. But
Yeah. I'm not. I will turn my video off. I apologize. I'm not sure what happened. It's some but I will go ahead and not delay any further and just to read my update with my camera off, if that's acceptable. So, hello and good morning, President Lawson, Vice President Dr. Heelser, Executive Director Varghese, and members of the board. I'm Melissa Gear, Deputy Director for Board and Bureau Relations. I appreciate the opportunity to share the Department of Consumer Affairs update this morning. My update is included in your materials under Agenda Item 7A. Please feel free to follow along as I highlight a few updates and reminders. On Governor's Executive Order. On January 29th, 2025, Governor Newsom released Executive Order N-1525, providing quick recovery relief for local businesses by deferring renewal fees and waiving other fees for DCA licenses in the Los Angeles wildfire areas. Specific DCA provisions include DCA licensees whose licenses expire between January 1st and July 1st, 2025 will be granted a one-year extension to pay the renewal fee if their business or residence address is in certain zip codes impacted by the fires. Licensees will still need to renew their licenses, but their fees will be postponed for 1 year. In addition, duplicate or replacement licenses or wall certificates will be provided free of charge until January 7th, 2026, and delinquency fees are suspended until July 1st, 2025 for those in the impacted areas. On January 29th, DCA met with Board and Bureau leadership to discuss the Governor's executive order and its implementation. DCA is providing consistent messaging to boards and bureaus for communication with impacted licensees and stakeholders. A dedicated disaster help center webpage, www.dca.ca.gov, a toll-free phone number, 1-800-799-8314, and an email, California, cafires@dca.ca.gov, have been set up to assist licensees and fire survivors. DCA has also updated board and bureau websites and created landing pages for renewal databases to inform users about the fee deferral. DCA encourages direct outreach to impacted licensees and expresses gratitude to the governor and board leadership for their support. Governor's 2025-26 proposed state budget. Governor Newsom released his proposed 2025-26 state budget on January 10th, which included 8 budget change proposals, or BCPs, for DCA's boards and bureaus. Additionally, DCA's vacancy reduction and government efficiency plans were approved by the Department of Finance and may be made official in the spring revisions. The governor remains committed to funding resources to address California's housing and homeless crisis. The governor proposed budget includes the creation of a dedicated California Housing and Homeless Agency. DCA and other regulators from the Business and Consumer Services and Housing Agency would form a new consumer protection agency. This is an extraordinary opportunity for DCA to better align with other consumer protection entities as one consumer protection agency. With a Consumer Protection Agency secretary within the governor's cabinet, this will only strengthen our mission, momentum, and delivery of services to California. The Little Hoover Commission and the legislature will review the proposal in the spring, and DCA will continue to update board leadership as more information becomes available. Form 700 filing changes effective January 1st, 2025. Effective January 1st, 2025, DCA board members must file Form 700 through FPPC's online system, replacing the previous NetFile portal. Additionally, paper filings will not be accepted. The FPPC emailed all board members on January 2nd, 2025 with a link to the FPPC portal and login information. As a reminder, the annual Form 700 filing deadline is Tuesday, April 1st. Please contact Board and Bureau Relations with questions regarding the new requirements at memberrelations@dca.ca.gov. And as I close, on behalf of the director, I would like to thank the board and staff for their hard work and partnership last year. We are excited about 2025 and the many opportunities that await us. Thank you for your dedicated service that protects California's consumers every day. I appreciate your time this morning and welcome any questions from the board.
Thank you, Ms. Gear. We're now going to hear from Ms. Nichols and Ms. Whitley from the Health Quality Investigation Unit, and we may be back to you shortly with some questions. Welcome, Ms. Nichols, Ms. Whitley.
Good morning. I am Chief Kathleen Nichols with the Division of Investigation, and also with me is Stephanie Whitley, Deputy Chief for the Division of Investigations, Health Quality Investigation Unit. It is our pleasure to provide the board an update on the Health Quality Investigation Unit, also known as HQIU. HQIU currently has 13 investigator vacancies, equaling a 16% vacancy rate. Between December 2024 and January 2025, 6 new investigators started, and we have received 2 additional final clearances for candidates who will start in March of 2025. This is a huge positive impact for HQIU to have 8 new investigators that have started. And in fact, one of our offices that historically had vacancies was our Fresno field office, and I'm pleased to report they are fully staffed with 7 investigators, many of which who came today. So I'd like to acknowledge them, thank them for their hard work, participation in the meeting, and a thank you to all of our investigators who are getting this important work done, protecting the public. In addition, we have 5 additional candidates in background, one of which is in the final psychological and medical portion of the process. In the meantime, we do continue to keep screening those applications and holding those panels every 30 days so that we can quickly fill the remaining vacancies. We are also excited to share with the promotion of 2 of our investigators to supervising investigators in November of 2024. We now have all of our supervising investigator and commander positions fully staffed with no vacancies.
Good morning. On January 23rd, HQIU medical consultants participated in their biannual statewide meeting, which included presentations on the unlicensed practice, corporate unlicensed practice of medicine, and various other topics. These meetings have been very well received and will continue on a biannual basis, giving our medical consultants the opportunity to collaborate on new ideas, efficiencies, and best practices. HQIU has made progress on pending workload and is working towards improvement regarding cases over a year old, as demonstrated in our updated graphs in your board agenda item 7B. In addition to sharing an automated monthly report with case status updates, HQIU leadership continues to hold weekly meetings with board staff to discuss cases, answer questions, and resolve issues efficiently. We also want to congratulate Ms. Charlene Smith on her new position as enforcement chief, and we continue our great working relationship with her. So we're very excited about Char. This concludes our update, and we'd be happy to answer any questions.
Thank you both. Are there any questions or comments for Ms. Gear, Ms. Nichols, or Ms. Whitley from the members? Dr. Mahmood?
Yes. What a superb job having all these investigators available now. So do we have now time frame when a complaint comes in and it completes? I know cases can be complicated and difficult, but now we should have some kind of time limit. Okay, this thing can be done in 6 months or 8 months or whatever, because some cases last way longer. And this, I think, is really a ray of light that we have everybody now in place in all the areas. So I just want you to answer.
Yes. And like you said, each case is different, so they all take their different twists and turns, but we're hoping that with the increased staff that we have seen the caseloads go way down. And that's important for two reasons. It's important for investigator retention, so it helps us keep our investigators to have a workable caseload, but it also helps us complete the cases faster. So right now, because we had staffing issues, we're still kind of trying to work through those oldest cases and being able to complete those with the hope that all cases eventually would be able to be completed in a year, and in a perfect world, 6 months. That's what we're working towards.
I too just wanted to highlight, as we are extremely excited to have all these new staff on board, that the time it takes to get them fully up running is a lot, and you guys are aware of how complicated these investigations are. So we have lots of FTOs who are specifically training our new staff, so some of their time is split with that, but that's just a matter of time, and we're just beyond thrilled to have this crew on board and some really great people who took this consumer protection job and are running with it, and we should be seeing those, the results soon. So very excited.
Thank you. Additional comments, questions from members? Okay, so we'll go to Dr. We got everyone on this side again. They're very interested today. We'll start with Dr. Thorpe at the end. We'll work our way back.
Thank you, Madam President. So it is encouraging to see on the graph on page 6C9 the average days to complete investigations in HQIU is significantly has a downward trend compared to years where it's been in the same level. So for the first time, it's below 500 days, which is, I think, something to be excited about, and hopefully that trend will continue. I'm assuming, we have to, and very encouraging to be able to get adequate staff, so to be more close to your fully staffed operation. Hopefully with more completion of that, being able to get more staff, that would help this even look better. But still, 500 days is almost 2 years. So it's still quite a ways. And we realize that these cases are complex, but I want to say, first of all, just we are excited to see that drop below 500 for the first time.
Yes, thank you. And it is an average of, so each quarter of all the cases we close, that's how they calculate what that quarter's case average is. And because we've been so diligent trying to finish all of the oldest cases as those close, it almost seemed like the better we did, the worse that number got for a very long time, because all the cases we were closing were aged. But now we're seeing that starting to trend back down, as it should, and I anticipate continued progress in that area.
All right, Dr. Yip.
Thank you. Somewhere in the report, probably not yours, there's a 7.5% required budget cut, or I saw something about cutting 2 or 3 vacancy. Now 10% is still high, and I think with the conversation before, how do we recruit? Is it through a common government job search site, or do we go to college graduate job fair, SIP recruiter, Indeed, to recruit future employee? I think 10% is still very high to me.
Mm-hmm. We're actively participating in career fairs. We just did a big one in Sacramento off Del Paso, where there was a lot of interest in our positions. So we're still continuing to advertise, participate in events, recruit new investigators. And in this recent budget drill where it was talking about everyone had to eliminate positions and vacancies, we were lucky, advocated for the importance of our positions, and none of our investigative positions were lost. They were exempt. So that was good. We lost 1 office technician position in our headquarters unit, and for the health quality investigation unit, that was the only position.
Thank you.
Mr. Watkins.
Yes, thank you. Well, I just want to say thank you to all the investigators that actually showed up today, but also to the greater community of HQIU staff for doing the work, because they actually do form the foundation of all these disciplinary cases that is more often than not more of the serious nature. So I've got two questions. You know, when you train new investigators or you have existing, you have to train them to the standard of clear and convincing, the standard of clear and convincing evidence. Is that a difficult task when you train these investigators to meet that standard? Or do you meet it or barely meet it, or do you meet and exceed it? That's my first question.
The standard for investigating the cases would be the same. And so as an investigator, you're compiling all the evidence, you're doing all the interviews. And in that respect, it's more of on the attorney end, on the back end, to be like, when you're all finished, what burden have you met? So certainly, because we know there is a clear and convincing standard, we do more tasks. We might conduct more interviews. We might, some of the delays we see is because we're fighting to get additional records. So if it was a lower burden of proof, we probably could stop at a certain point. But that's why our cases are so thorough and complex, because we are working towards that standard so that we can have a successful outcome on the back end. But the training process is the same. So, you know, even if that burden of proof were to change, although it would make it easier in the sense there might be less steps, training our investigators, we want them to conduct a thorough investigation on both sides, both for the patient side and regarding the physician, making sure that we have all the information so that when it goes to an expert reviewer, they're making their opinion based off of this massive information that we've compiled.
Yeah, and thank you. My second question is, I see that there's 500 days, that's a year and a half right now. That's to process the case, right? I want to know more or less how many cases gets referred to HQIU in a fiscal year, as an example. I don't know if you know that. Tell me.
We have that data. It's actually in the annual report.
Yeah.
With how many cases we have received per fiscal year. It is reported in the annual report.
Check that out.
I'll have to get the statistics as to where we are to date, and we could get those figures to you.
I appreciate that. Thank you. Thank you. Ms. Gay as well.
Dr. Bola.
Yeah, I'm just going to be very brief. I just want to acknowledge the people in the back there that showed up. I mean, I think that's really impressive. And I do want to say that these positions are very important to all of us, wherever we're all health consumers in the state of California, regardless if we're physicians or not. And so thank you and congratulations on making this, and be looking forward to seeing those numbers to continue to dip down. Thank you.
I want to get a little emotional because, and especially Kathleen and I, our careers started in consumer protection at the medical board as investigators. And one of my first cases that was egregious, I saw a doctor's license revoked, and knowing as an investigator, my work went to protect those consumers. Anytime I'm able to swear in a new investigator, I said that's what hooked me, knowing that my work has protected the consumers of California and how very important and very skilled our job is. And we're like no other in the state that we get that opportunity to make that impact. So I'm just super excited, again, like you guys said, to have those new folks up there and to take that challenge on. So thank you.
Thank you. Additional comments, questions from board members? Any questions, or excuse me, public comments from those in the room? All right, Sean, let's go to public comments on WebEx.
Yes, if you'd like to make a public comment on agenda item number 7, please do so by raising your hand, typing anything into that Q&A window. If you're on a call-in only line, you can press *3. First question here we have is from Denise Johnson. Denise, you should be receiving that prompt on your end.
Again, good morning, President Lawson and the members of the board. My name is Denise Johnson. I am from Tracy and a volunteer with the Consumer Watchdog. We are very pleased and interested in hearing about the process to create the Consumer Protection Agency. It seems like a great concept, but we have little faith in this board and your ability to work within a consumer protection agency that would actually come forward with policies and legislation that would protect the public. We will be looking forward to the proceedings with the Little Hoover Commission and speaking to the legislature to see how we can make this a consumer protection agency that does the work to protect consumers. Thank you.
Thank you for your public comment. This time I don't see any additional requests in queue.
Great, we'll bring it back to the board. I'll check one more time in the room. Not seeing anyone. We're going to move on to agenda item 8. I did want to let the board know and anyone who might be listening in, we will take a lunch break, most likely after this item, for some period of time. We'll announce when we'll be back, but I just wanted to give everyone a heads up that for agenda item 9 and 10, we're likely going to be taking those after the board takes a lunch break. But before lunch, we're going to hear from Aaron Bone for a discussion and possible action. I guess maybe not possible action. That's the board agenda title. Discussion on legislation.
At minimum, discussion, Madam President. Good morning, members. Nice to be before you all again. So after a ceremony in December to swear in the newly elected members of the legislature is back in Sacramento, starting in earnest in early January. Legislators are working quickly to meet their bill introduction deadline of February 21st. Speaking of new legislation, after the last board meeting, we began working very quickly to find a bill author for the board's Physician Health and Wellness Program proposal. I'm very pleased to share that with the assistance of President Lawson, Vice President Helzer, and the rest of the executive team, that Assemblymember Mark Berman has agreed to author the board's legislation. Mr. Berman is also the chair of the Assembly Business and Professions Committee, which is expected to be the key policy committee in the Assembly that will be evaluating this bill. As you can see, it's a very brief staff write-up. AB 408 is our number, and it's currently a spot bill. We included that in that document, the key legislative deadlines for the rest of the year so the members can get a sense of the pacing of the legislature's work. At this point, the staff will be working with the author's office, President Lawson, Vice President Helzer, to amend the bill in line with the board's direction. The members may be interested to know that since the November board meeting, I think Mr. Varghese mentioned this, we've met with relevant organizations to hear their perspectives on the board's proposal, and we look forward to having additional conversations. Those who wish to engage with the board in this legislation are certainly welcome to contact me. Lastly, although there's only one bill on the agenda for this meeting, I do expect that the May board meeting agenda will have quite a few more bills to discuss. The May board meeting agenda is after bills that are moving this year have been heard in one or more policy committees and after that bill introduction deadline. That concludes my prepared remarks, Madam President.
Thank you, Mr. Bone. Any questions, comments from members? Mr. Watkins?
Yes, your discussions with all the relevant parties about the PHP program. I am just a little bit, I would be remiss if I didn't mention this, the fact that, I think there was a little bit more consensus on the board that we may want to do a stakeholder meeting, that people could get an opportunity to add to that space, to add their comments, and I think the folks out of San Diego was present, and they were expressing a willingness to add to the conversation, and some of the other patient advocates. And I'm just concerned that we will bypass that and not give the people an opportunity to give their opinion.
I have a question. Thank you. Ms. Mitchell?
Yeah, Mr. Bone, the legislative process, when bills are heard in committees, are those open to the public?
They are indeed.
Okay, so that would be an opportunity for advocates to speak directly to the legislators that are working on the legislation, voting on the legislation, et cetera.
True.
I just wanted to make that clear. So We have the bill number, that's public information. There's legislative tracking via the web that you can follow and then also participate. You can write letters to the committee, to the author. You can participate in, testify at hearings before the legislature.
Speak to your own elected member,
Yes,
depending on
yes.
where you live throughout the state.
Reach out to your elected official, et cetera. I just want to make sure that everyone knew that process. Thank you.
Yeah, just to add on to that a bit as well, and to provide some insight into the, frankly, level of stakeholder outreach there has been from the last board meeting date in November of 2024. Dr. Helzer and I have participated in those meetings and in providing direction to our staff to make sure to do outreach to patient advocacy community, consumer community. We met, gosh, was it this week or last week? And remind me of their new name. I mess it up every time. CPPC.
CPPC.
CPPC is the former CIPL.
Yeah.
Center for Public. It used to be Center for Public Interest Law, I think.
The University of San Diego, which
at
may
the
have been the
University of
group
San Diego,
that
which
Mr.
is
Watkins was
so we've
referring
met
to.
directly with them, and Dr. Helzer and I are participating in all those meetings and hearing their feedback. We also understand from interacting with the committee staff that those organizations are also interacting directly already with whether it be Assemblymember Berman's office or with others. So this is going to be a very public process, to Ms. Mitchell's point, but it has also been a very interactive stakeholder process in terms of what I understand the delegated authority to Dr. Helzer and to me was to go find the author to help this work its way through the process. I would expect we'll be participating in the committee hearings once those are scheduled and come to pass as well. But again, there are lots of opportunities for the public to participate. One of them is this opportunity here. We're meeting as the Medical Board of California today, and this is on our agenda for a conversation. So to the extent there's something that folks want to weigh in about, I would encourage you to do so today as well.
And my point is, and this concerns me when I'm in the board, is what we said we were going to do, we actually didn't. I know there's all these opportunities that the public will have, but this is the first stop, right? Once this thing hits the legislature, it becomes more cumbersome, even in that public domain. And the board is the first stop where people can feel that they have a voice. The stakeholder meeting in a public forum is what I suggested in the last meeting, which I said there would be consensus of. So that is being bypassed. I accept that because it's not the first time that the public is getting passed over. That genuinely concerns me, and I'm just going to leave it there.
With all due respect, the board did not provide direction to us to have a separate stakeholder meeting. And we are, the suggestion that in any way we are excluding the public from this extremely public process where, our staff has done a tremendous amount of outreach over the past few months to all of the stakeholders we know and have known for years are interested in this type of program. I find that misrepresentation, Mr. Watkins, offensive. It's not accurate. It's a misrepresentation of what this board is doing. And again, the public, it's on our agenda today for exactly the reason that if stakeholders are interested in this topic, they should come and talk to us. This is our scheduled board meeting. It's on our agenda, and I'm not sure what more we really can do.
What we could do is, as we said in the last meeting, when I asked this as, a future agenda item, there was consensus, or maybe I misread the room, that the stakeholders would have an opportunity more than 3 minutes to engage across a room and kind of get a better feel. The purpose behind that was to build trust at the board level. But now what I'm saying is that this is just going to move on, which was everybody's fear at the time. And that's okay. I understand the process. Everybody understands the process. We've gone through this. This is not a misrepresentation. I can point back to the record that is what the spirit of that conversation ended like that, even though the vote moved it forward. And I'm just going to leave it there. but I'm not misrepresenting anything. And what I am doing is pointing out that there's a shift. And I mean, I'll let the public weigh in on this.
Other comments?
I'm sorry. To see the undermining of institutions in this country that's happening right now is a function of people misrepresenting the facts. And I just, it's so upsetting to me to see the facts misrepresented in this situation, to say that we're bypassing consumers, that we're bypassing patients, that we're doing anything except being very public, offering a public opportunity for people to speak on this item, having had many meetings prior to this, 3-hour experts at the board meeting, a long discussion at the last one. We did not direct anyone to do a follow-up meeting because we understood the process at the legislative level, which was a very public process with full-time staff, full-time members of the legislature who would be vetting this out very thoroughly, who have multiple experts on their team, and their job is literally to listen to the public. So I appreciate the public wants to be involved, and we want them involved, and the legislature's job is to have them involved, but to suggest that this board in any way, at any time, and I realize that I'm new to it, but has not included patient input is completely false. And making false statements from the dais as an appointed member of this commission is what undermines the credibility of institutions and why we see unelected billionaires destroying our government in this country. And so I can't do anything about Doge and Elon Musk, but I can say when it's happening at our board meeting, I must speak up and say, this is not right. This is not true. The board members did not say this, and what is being said is completely false and misrepresenting what this board is trying to do. And it's so upsetting to me because we see this pattern destroying our institutions and destroying our democracy at the national level. So I would ask that
Can I
we
respond
take
to
that into
that?
consideration.
I would like to clarify. Indeed, the board member is correct. The board member is actually 100% correct that the board did not instruct that we should have a stakeholder meeting. I infer that. That is the truth. And if that is the misrepresentation, my inference, in the spirit of the discussion, then absolutely I take ownership of that. But this is where I take exception. And I do take exception that somehow I'm undermining this board. I'm critical of this board because of our enforcement practices, absolutely. But I believe in this board as a foundational institution to protect the public. And my efforts here has all indicated that. It may not have been in the seam of how things are done, but it is from a huge public protection background. Thank you.
Other comments on the legislation we have pending? All right, we'll open it up for public comment. Anyone in the room? We finally got a taker in the room.
Hello, my name is Lucas Evanson, and I'm speaking on behalf of the California Medical Association. We appreciate the work done by board staff to secure an author for the Physician Health and Wellness Program legislation, now AB 408. We look forward to continuing to work with the board, Assemblymember Berman, and the rest of the legislature as it progresses through the legislative process. Thank you.
Thank you. Let's go to public comment on the WebEx.
Thank you. If you'd like to make a public comment here on this agenda item, please do so by using the hand raising feature, typing anything into that Q&A window, or if you're in a call-in-only line, you can press *3 to toggle raising your hand. First up here, we have Monique Hines. You should be receiving that prompt on your end.
Bakersfield and a volunteer with Consumer Watchdog. As a team, we are all here because we lost our precious family member. In my case, I lost my grandson to medical negligence. This isn't something we chose to do, which is to commit our time and efforts in either making positive change to save other families or to protect consumer protections that someone fought for us to protect. In this case, we are here fighting to preserve consumer protections that others fought for us. I was disappointed to hear that this board so swiftly took the first steps to not adhere to hard-fought protections for families and for substance abusing physicians.
Did that line get cut off?
Monique, are you there? She still shows online, but we're not getting any more audio from her.
Why don't we press pause on her? And I'm not sure if she can hear us, but it sounds like you may have been cut off. If that's the case, we'll come back around to you. Sean, do you want to move on to the next? And then
Yeah, actually, her thing's not responding, so it looks like she maybe lost connection here. Next up here, we have Michelle. I believe Michelle Montserrat Ramos. You should be receiving that prompt. Morning, Michelle.
I was disillusioned to hear that your consultant took his best shot at patient advocates to make the public statement be the public as to this.
Sorry, can I pause you for a minute? It looks like
Did they hang up on me?
No.
You know what?
no one's hung up on anybody. Sorry, just hold for 1 second. It looks like we had a technical problem on the first commenter's line. It went dead for a while, and then you both came back at the same time. So we're going to reset. Sean, can you go back to the first commenter? We'll make sure we get that comment in first, and then let's go to Michelle second once that comment's done.
Will do. Michelle, if you could re-raise your hand too, that'll make sure I get you on the next one. Going back here to Monique Himes, you should be receiving that prompt again.
Hello.
We lost you about a minute in there, so if you want to just restart, we'll go ahead and restart your time.
Okay. I am Monique Himes. I'm from Bakersfield and a volunteer with Consumer Watchdog. As a team, we are all here because we lost our precious family members. In my case, I lost my grandson to medical negligence. This isn't something we chose to do, which is to commit our time and efforts in either making positive change to save other families or to protect consumer protections that someone fought for us to protect. In this case, we are here fighting to preserve consumer protections that others fought for us. I was disappointed to hear that this board so swiftly took the first steps to not adhere to the hard-fought protections for families and for substance abusing physicians. I was disillusioned to hear that your consultant took his best shot at patient advocates to make the public statement that we, the public, are not capable of contributing to this discussion. But that wasn't enough. No one from this board stood up for the public. No one could say that they respect our opinion. No one could say that we stood up for you and helped you when you needed help. We don't support your efforts to strip California patients of any protections we currently have and the transparency those protections afford us. We oppose your efforts to overturn 2 laws and not adhere to the uniform standards. Attempting to minimize our effectiveness and contributions as patient advocates will not deter us. Thank you.
Thank you for your public comment. Gonna go back to Michelle here. Let me find you here in this list. Okay, Michelle, you should be receiving that prompt again now.
I am Michelle Montserrat Ramos. There are so many issues to cover here. You know how I feel about your plan to overturn 2 laws, not adhere to uniform standards, and leave the public to fend for themselves. One thing I have to say is that you really let the public down at the last board meeting in Los Angeles. Not only did you not take into consideration any of the public's concerns with your legislative plan, but you took it a step further. You went along with your quote unquote consultant who took the public to task, expressing that the public has nothing substantial to add to this issue. He expressed how none of us have been harmed or lost a loved one at the hands of a substance abusing physician, which all of us know is not accurate. We thought that we had done enough work to attempt to build some form of working relationship with you, but you turned your backs on the public, especially all the public board members, with the exception of Mr. Watkins, who was the only member who was willing to listen to the public and attempt to convince all of you to try to form a compromise. You have taken out $24 million worth of loans and are admitting that you may have to take out a $27 million loan this year to stay operational. You seem to have forgotten who lobbied to make sure that you did not get the fee increase you needed to survive. You also seem to have forgotten who advocated for this board and helped you fight to get the fee increase you did receive. For those of you not in the room for the past year or so, it was us, the public, this team who advocated and fought for your fee increase. So yes, we do understand the legislative process. In addition, let's take a step back and reflect on the ABC 10 news segment about the diversion program. Our board president was asked by the reporter, didn't she feel that the public had the right to know if their physician was a substance abuser? To remind you of her response, she responded that if the public has a concern and feels their doctor may have a substance problem, then they need, meaning we need to file a complaint. How's that supposed to work? Now that you plan on putting all the responsibility of evaluating and monitoring substance abusing doctors on us, the public, when are we supposed to file this complaint? In pre-op in our hospital gown? I actually know of a Californian who found himself in that exact position. He was in pre-op. They had already started giving him some of the anesthetic medication when his doctor dropped by. He could smell alcohol in his breath. He told the doctor that maybe they should reschedule the surgery, and the physician said, no, it wouldn't be a problem.
30
Before
seconds
the
remaining.
patient could utter another word, the anesthesia did its job and he went under. The procedure was done, and he's still suffering for the problems that occurred during his operation. It is not our job to evaluate substance abusing physicians. It's your job to monitor substance abusing physicians and take action to protect them and the public.
Thank you for your public comment. Next here, we're going to Tracy. Tracy, you should be receiving that prompt on your end.
You hear me?
Yes, we can, Tracy. Please go ahead.
Hello, I'm Tracy Dominguez. I am from Bakersfield and I'm a volunteer with Consumer Watchdog. I was at the last quarterly meeting and I did share my concerns with the legislation to overturn two laws and to not follow the uniform standards. I have lost my daughter, my grandson. I lost everything. I keep coming to these meetings and continue to advocate for change and to protect the few consumer protections. And we do have, because I know what happened to my family will occur to happen if we didn't advocate for change. As a team, we never felt so attacked. We never felt so unheard. It was a concern when this board did not take any of our concerns into consideration, but you took our concerns to a different level when you brought in a consultant into the meeting who chose to try to minimize our voices. It appears that it was just a job to attack the patient advocates and the public in attending by stating that we had nothing to contribute to this conversation. When you brought him in, it got worse. Not one board member, especially the public board members, said anything to support the public. In fact, that none of you said anything in to support this public spoke volumes to us. I still oppose this legislation. It appears that our board president feels that if a patient's responsibility determines of our surgeon or our anesthesiology are substance abusers and make a mistake, it's our responsibility to take action. And consumers, you have faced a 27 million loan this year, yet you still moving forward with legislation that will remove consumer protection with no funding for this program. We have not lost our voice. We are still here and we are not going to go anywhere. Thank you.
Thank you for your public comment. Next up here, we have Eric Andrus. Eric, you should be receiving that prompt on your end.
Hi, can you hear me?
We can. Please go ahead.
Oh, Christina, I saw you roll your eyes when TJ was speaking. That's just so unprofessional. Everyone can go back and watch the video of you doing this at around 11:08 a.m. And it was inferred there would be a public stakeholder meeting on this issue. Consider this a public record request again for documentation on what was said at that meeting. Christina, you're getting so disrespectful and confrontational when things don't go your way. This is you trying to railroad another program through without public input. Whomever that woman is who doesn't like the misrepresentation of facts needs to take a step back, as she clearly doesn't know the history of this board trampling over public participation and closing down interested party meetings. Do some research on the board history before you put your foot in your mouth. You're undermining this board now. Judge Catherine Feinstein resigned this board because it didn't fit with her morals. You are out of line and clearly have been instructed to be pro-board no matter what. I'll go back and look at the meeting video and post it to social media. But even if a public participation wasn't scheduled, you all should be backtracking and promising it now instead of arguing over it. The egos are getting out of hand. Now we've got a new board member being offended when she has no idea how poorly advocate participation has been trampled over the years. I remember in a number of meetings in years gone by when the board told us as advocates that certain things we asked for would require getting a legislator to propose a bill to change the law, and that the board doesn't do that. We'd have to do that ourselves. Now it seems that the board itself has found a legislator for the Doctor Health and Welfare Program. Wow, what a miraculous change of events. First, you tell us that we have to do it ourselves because the board won't do it. Now, Christina just goes out and gets a legislator to do it for her pet project. It's interesting that the things that we are told to us for your convenience. I remember Denise Pines telling me you couldn't change around the agenda items, and then we saw it happen multiple times over the years. This is why we don't trust you all. You tell us things for your own convenience that simply isn't true. It's like Carrie saying that the board hasn't adopted Robert's Rules of Order. I found it right in the board manual, and now she's trying to repeal it. So how's that for undermining board and public trust, misoffended board member? Thanks.
Thank you for your public comment. Next up here we have Xavier De Leon. Xavier, you should be receiving that prompt on your end.
My name is Xavier De Leon, a volunteer for Consumer Watchdog, calling from Bakersfield, California. I was present at the last quarterly meeting that was in LA via WebEx, and I'd like to say something. I'd like to say after that meeting, it was even more clear to me that you guys don't value us as patients or advocates. You chose not to offer any change or amendment to your legislative proposal to meet the needs of the public, and after the discussion on the diversion program, I was discouraged even more. But the biggest slap in the face is when you sat while, oh my gosh, I'm sorry. But the biggest slap in the face is when you sat by while your consultant did his best to diminish our abilities and advocacy team. And not one of you said something in support for us. You can try to flip the responsibility on us to evaluate substance abusing physicians, and you can try to minimize us as patient advocacy team, but it will not stop us. We will keep coming back to these meetings stronger to fight for the rights of our families that died due to maternal negligence and for the rights of families who have yet to be harmed or die. Thank you.
Thank you for your public comment. Next here we have Denise Johnson. Denise, you should be receiving that prompt.
Again, good morning, President Lawson and members of the board. My name is Denise Johnson. I live in Tracy and a volunteer with the Consumer Watchdog. Having attended the meeting in November, I have to wholeheartedly join my fellow team members in expressing my disgust in this board's proceedings during the last board meeting's discussion of the diversion program. I felt victimized all over again. It felt similar to when I left the hospital without my son being heard and with no accountability for him. Your consultant, he did his best to dispose of us and minimize our contribution as patient advocates and as a team. I suppose that was the job given to him. For us to sit there and hear him say that we, as patient advocates, had nothing to contribute to this issue was outrageous. Even more outrageous was watching each and every board member sit there with no response, no support. Not a one of you felt the need to say that you respected the public's opinion, that you respected our opinion when you needed help getting a fee increase. You had no problem asking for our help, and you got it. We delivered for you. Yet you are determined to take away any protections we had as patients and will slap us while doing it. Your consultant did his best to try to minimize our voice, but all he did and all you did was anger us and make us even more determined to fight back and fight for our rights as patients. Thank you.
Thank you for your public comment. Next here, we're going to Marion Hollingsworth. Marion, you should be receiving that prompt.
Hello, can you hear me?
We can. Please go ahead, Marion.
Okay, thanks so much. This is Marion Hollingsworth, patient safety advocate. I resent the fact that this board and this new board member claim that they listen to the patient voice when it is so far from the truth. It is pathetic. Harmed patients and advocates are routinely ignored. The board listens to the CMA and doctors all the time. Stakeholder meetings are rarely held. And when they are, it's up for us to shell out the money to travel to the meetings to attend. If we don't attend in person, we may get a few minutes to talk and a thank you for your comment like we do at these meetings. The bottom line is you don't listen to us until we get the attention of the LA Times or KNBC or other media, and now even John Oliver, who embarrasses you into acting. The board member who spoke, I believe it's Wendy Mitchell, has not been here long, nor has she experienced Dr. Harm. She is not experienced with reading literally thousands of board documents like I have. I have been attending meetings since 2014. Time and time again, there is an important issue that affects patient health and patient safety, like the probation notification issue. And time again, it's just ignored. Another example is sexual misconduct cases. We advocates compiled lists of doctors who were still able to practice despite multiple victims and multiple complaints. It wasn't until a couple years ago when the LA Times ran an article on doctors who had been revoked for sexual misconduct and then suddenly reinstated that this board and the CMA suddenly grasped their pearls and thought it reflected poorly on them. Only then was a bill passed that would have prevented these doctors that will prevent these doctors from getting reinstated again. I was the one who gave the LA Times those doctor names. Doctors at this board continually gave a pass to, ones whose victims even included minors. So the bottom line was you listened to the CMA and not to us, the public. The board continually ignores the patient voice, both at meetings and during investigations. And because you continue to dismiss our voice, we continue to come to these meetings and talk to reporters because at least the reporters listen to us. You can do better. Thank you.
Thank you for excuse me. Thank you for your public comment. Next up here we have Maria Ibarra Navarrete. You should be receiving that prompt again.
Yes, my name is Maria Ibarra Navarrete. I am from San Jose. I'm a volunteer with Consumers Watchdog. Thank you, Mr. Watkins, for taking a stand today and speaking up that we, the consumers, need more than a 3-minute comment, but an open dialogue. I have never been disappointed as I was when I left the last medical board meeting following the discussion of the diversion program. I was extremely disappointed because the board was determined to follow the program to not adhere to the uniform standards. We all know that was your call to action. It had nothing to do with the best practices, and it had everything to do with the call to make sure that substance abusing doctors have no accountability and no consequences. You didn't stop there. You allowed your consultant to insult us, insult the public, questioning our intelligence and ability to engage in this issue that not only affects those of us who have been harmed or died due to substance abusing doctors, but every single patient. All of you sat there and allowed him to question our right and ability to engage in this discussion. Not one of you felt the need to speak up until today. Mr. Hawkins did state that you respect the public's opinion because obviously you don't respect our opinion. You have made the public feel as we do not matter, You have tried to minimize the effectiveness of our advocacy, but you won't succeed. You certainly need us when you certainly needed us when you needed your fee increase, right? And we were there to support you and advocate for it. Now you think that this board can dispose of the public? Well, the public and the patient advocates cannot be disposed of. Our families were disposed of due to medical negligence and your lack of holding physicians accountable for their actions. What this board can do is what OMBC did. Schedule a meeting with advocates that can provide input, implement it accordingly, just like OMBC did. You can go watch that meeting and be educated of what OMBC has done with advocates. So there is more that can be done. This is not just it. There's always something that can be done. You have to realize that the more you try to push us away, the more we will fight back. Thank you.
Thank you for your public comment. Next up, we'll have Alka Eri. Should be receiving that prompt on your end. Morning, Alka.
Hello?
Yes, we can hear you. Please go ahead.
Oh, fantastic. Thank you. Hello, I'm Alka Eri, and I'm from San Francisco. I'm a volunteer with Consumer Watchdog. For those of you that don't know my background, I'm a former investment banker in the healthcare industry. I advise early stage companies on capital raising and strategic options, so I understand financial statements, budgets, and forecasts. I lost my older sister, a research scientist, to a preventable anesthesia error. This medical error was so severe that she needed a lung transplant, but never received one. I witnessed physicians prioritize their livelihoods over her life. And for that reason, I'm committed to attending your meetings until I can make a difference on behalf of the thousands of injured patients who can't come before you. I've attended board meetings over the past year discussing this physician wellness program, and I'm astounded by how this board has consistently ignored feedback from patient advocates. Not one patient advocate or patient advocacy organization has expressed support for this wellness program during the 3 minutes we're allowed to speak. By providing near unlimited time to others to propose and defend this wellness program and not providing an equal amount of time to those that oppose it, you have demonstrated your bias in an incredibly overt way. In case it wasn't clear, most of the patient advocates that attend and speak at your meetings are volunteers. No one is paying us to be here. We speak on behalf of loved ones killed or injured by medical negligence and denied justice by this board. We come from all different backgrounds and from every corner of this state. We have overcome profound grief to speak about preventable deaths and why we believe it's unwise to pursue a physician wellness program. Our point of view is centered on common sense, but much of it has fallen on deaf ears with this board. I've heard some of your staff and guest speakers denigrate our intelligence, competency, and understanding of the situation without giving us an opportunity to respond. Except for Mr. Watkins, I haven't seen any attempt from this board to show grace toward our point of view, the patient point of view. But please remember, physicians aren't the only stakeholders in this conversation. When this board can't adequately provide physician oversight and patient safety without obtaining loans from the Auto Mechanics Association, how can this board pursue the creation of an entirely new program? Have you no sense of fiscal responsibility? Is it a wise use of this board's and the board staff's time to pursue endeavors it can't outright fund? To put things bluntly, you need to get your house in order before you spend any more taxpayer dollars. Financial insolvency isn't something to be proud of and shouldn't be ignored. While Mr. Varghese' update today is promising, it has yet to materialize, and your track record thus far speaks for itself. We all have our reasons for supporting or opposing a physician wellness program, but I hope we can all agree that fiscal prudence and some common sense is needed now. Your time would be better spent focused on fulfilling your existing obligations of oversight and enforcement and finding a way to do so without a bailout from another government agency. We need to get back to basics before adding more obligations to this board. Thank you.
Thank you for your public comment. Next up here, we'll be going to Rob Gordon. Rob, you should be receiving that prompt. Morning, Rob. Are you there?
Yes, can you hear me?
We can. Please go ahead.
Yeah, boy, thank you for that last caller. Just nailed it. Thank you so much, whatever your name is, for saying that. I don't even know where to start. This is like being in an alternative universe. I did listen to those the videos from the last meeting last time. You guys don't get it on the board. TJ is trying to save your board, but it's too late. I want to propose something to the advocates out there. We really have to establish and abolish the Medical Board of California movement. If anybody wants to help or join me in this, my phone number is 858-848-5001, or you can reach me email rob@action.associates. That sounds impossible, getting rid of the Medical Board of California. It can happen. There was an agency called the California Trade and Commerce Agency. They became dysfunctional also, and the legislature acted quickly. They got rid of them. What they're doing is loopy. I'm sorry, guys. Medical Board of California, you are stuck in groupthink. Wake up. Your one-way system of communicating has failed. Your organization has failed. I've done this for 5 years now. I'm done. I've spent hundreds of hours of my time. So I have to switch gears now. TJ in one of his talks at the last meeting was talking about, oh, people will be on the defensive. No, we got to stop being on the defensive. We got to go on the offense now. And I think this physician health wellness program is a bit of a distraction. Get us all fighting over this, like there's a fire in the kitchen, but you're talking about how great the drapes can be and stuff. The bigger issue is, at best, you need to be re-engineered. At best, you need radical surgery, but I don't think we can do it. I think California has to do something different. Thank you for listening.
Thank you for your public comment. At this time, there are no additional requests in queue.
Thank you. Are there other public comments from those in the room? Okay, seeing none, I'm going to bring it back to the board, and I feel the need to set the record straight on a couple of fronts. The purpose of the physician health and wellness program is patient protection. It's to make sure that at the earliest possible time, before any harm can be caused to a patient, before a substance abusing or otherwise unwell physician interacts with a patient, that we catch those physicians and get them into treatment. We have had 4 public meetings in the last 12 months on this topic that this board itself has hosted. We hosted a meeting on May 24th, 2024, where we heard from experts about how these programs are designed and successfully implemented across the country. And I want to remind us all that we're one of a handful of states that does not have a program like this. Right now, we're doing nothing. What the board is telling you is that we want to do something about this problem. On October 24th, 2024, we held an interested parties meeting, a formal stakeholder meeting that everyone was invited to come and provide their feedback on this type of program. At our November 20th quarterly board meeting, we also considered this and decided to move the legislation forward and granted delegated authority to Dr. Helzer and to me to work with our staff to make that happen. And now in February, we are holding our 4th meeting again in 12 months on exactly this same topic. The idea that we have not asked for public comment and that we have not provided opportunities for public participation is false. We have gone above and beyond. This has been the most comprehensive public participation outreach process since my time on the board. I would also like to add, our May meeting was in Sacramento, our November meeting was in Los Angeles, and our February meeting now is in Fresno. We have been to Northern California, to Southern California, and we're here in the Central Valley today so that we can receive public comments from everyone who wants to interact with this board in person in your communities. As we talked about earlier in this item, since our meeting in November, Dr. Helzer and I have worked with our staff to do more individualized outreach to many members of the stakeholder community. And I would urge Consumer Watchdog to accept our invitation to meet with us, to meet with Dr. Helzer, to meet with me, and to meet with our staff, so that we can hear from you directly, like we've heard from other stakeholders directly in this process. Other comments, questions from members before we break for lunch? Dr. Thorpe.
Well, I would just say, number one, I think that's a very appropriate review of the process. That this is not about trying to allow doctors to practice under the influence. This is exactly the opposite. This is these are in fact well-proven pathways to provide the most opportunity to the most likely people who need the help to get the help as early as possible and not cause patient harm. We are trying to design a program that is the most effective program and that follows national best practices to do that, with the guidelines of the American Medical Association, with the guidelines of Washington State has a very successful program. This process is not about protecting doctors. This process is totally about protecting patients and getting substance abusing doctors who are under, I'm not making excuses. It's just there are people, they're part of the population, and there are people there who are having difficulty. They need to get in help as soon as possible, and they need as little barrier as possible to get into help. This program is trying to design that program in a way that is going to be the most effective. There's no point in creating a program that nobody's going to use. So I just would say, and the idea that we haven't engaged the public is inappropriate. I'm sorry. Thank you.
Other comments?
Yep, President Lawson, thank you for taking the delegated authority, and Dr. Helzer for moving this forward. I think that apologies to the public if they felt disrespected. We expect here at the medical board the conduct amongst ourselves and with the public to have one of civil discourse. I think that understanding that prevention does matter, I think was a key statement that you made, President Lawson. We don't want to talk about it ex post facto. We want to prevent it at the beginning. People, doctors have problems just like anybody else. Catching them early can prevent problems and protect the public. So thank you for that acknowledgement.
Thank you. Any more comments before we break for lunch? Dr. Yep.
I really appreciate your leadership, and actually we're fortunate that you and Doug House get a legislature to support the bill and effort. It's only the beginning, and it really takes a lot of effort between the public, means doctors and public, and our staff. Ms. Torres and I were in one of the interest party meeting, and we did try our best to attract more. But if the leadership feel in the future with the legislator call for, I'm sure some of the board members are willing to do in-person stakeholder meeting in San Diego, Fresno, Bakersfield, whatever, to make the partnership goes. This is a long process. As Dr. Tsai say, we decide to build a house, we need to bring an effort to build the right house for all parties involved. And I applaud your leadership with Dr. Hauser and Reggie. Thank you.
Other comments? All right, we are going to break for lunch until 1 p.m., if that's acceptable to everyone. All right, so the board will be back in session at 1 o'clock. Thank you all. All right, welcome back to the Medical Board of California quarterly meeting. We're We're going to move on to agenda item 9, which is discussion and possible action on proposed rulemaking on fees for petitions for penalty relief and proposed responses to public comments received during the 45-day public comment period. Carrie, I think I'm turning it over to you.
Yes, thank you, Madam President. Members, please turn to the materials under agenda item 9. At the board's request during its last sunset review, Senate Bill 815 added Business and Professions Code Section 2307.5 to the Medical Practice Act, giving the board the authority to establish a fee for petitions for penalty relief, which shall not exceed the board's reasonable costs to process and adjudicate the petitions. Board staff determined that the average cost to process a petition for reinstatement through the hearing process is $22,781, and the average cost for petitions for modification or early termination of probation is $20,992. At the May 2024 board meeting, the board approved proposed regulations to establish fees for petitions for penalty relief to cover the cost to process such petitions up front before the matter was referred to the Attorney General's office and set for hearing. The proposed regulations were noticed for the 45-day comment period, and the board received 9 comments. A summary of the comments and proposed responses are included in the materials, as well as the actual comments. All of the comments express the concern that requiring petitions to pay in excess of $20,000 upfront would be a barrier to individuals who are rehabilitated, yet unable to pay the costs and pursue the penalty relief. While board staff do not agree that the originally proposed regulations violate the right to due process nor equal protection, board staff developed an alternative proposal for the board's consideration to address concerns raised about the upfront costs. To be clear, government agencies may impose fees in the amount necessary to cover the reasonable costs of providing services. Board staff provided the itemized workload descriptions in the materials for the initial work that board staff do to process such petitions, and the historical average costs for the services provided by the Attorney General's office and the Office of Administrative Hearings. Nonetheless, under the alternative proposal, individuals seeking reinstatement would be required to submit $2,962 along with their petition, and individuals seeking to modify or terminate their probation early would be required to submit $1,242 with their petition to start the initial review. These fees represent the cost to the board up to the time the petition is referred to the Attorney General's office. The remaining fee to pay for the services of the Attorney General's office and the Office of Administrative Hearings under this revised proposal would be determined by the administrative law judge, who shall consider the evidence of the petitioner's ability to pay the remaining fee with or without entering into a payment plan, as well as the reasonableness of the fee. This proposal includes a cap of $22,000 less the initial fee already paid. Under the modified proposal, the board may approve, reduce, or eliminate the remaining fee proposed by the ALJ, and may also increase the award consistent with the evidence in a decision after non-adoption. Additionally, the modified text clarifies that these fees would apply to decisions entered after the effective date of this rulemaking. And that modification was made to address a concern that individuals who stipulated to go on probation did so without factoring in that they would have to pay to petition for penalty relief. The modified text also sets forth the notice that board staff must send to petitioners to alert them that the petition has been accepted to be set for hearing. The ALJ may include an order for the board's consideration and approval for the petitioner to pay the remaining fee to cover the reasonable cost to process and adjudicate the petition. up to $22,000 less the initial fee already paid. That at the hearing, the petitioner may submit evidence regarding their ability to pay the remaining fee or challenge the reasonableness of the remaining fee being requested, and that the petitioner may be ordered to pay the remaining fee regardless of whether the petition is granted or denied, because it still costs the board money. Some commenters pointed out that the board could hear petitions directly and not have hearings go through the Office of Administrative Hearings. However, board staff do not see this as a cost-saving measure because an administrative law judge would still have to participate to make rulings on objections and the admission of evidence, among other things, as well as to prepare the decision reached by the panel. Additionally, this could increase travel, lodging, and per diem costs for board members and staff. The modified text is included under attachment 4. I'm happy to answer any questions the members may have. And if the members are so inclined, I have a suggested language for a motion.
Questions, comments for Carrie? Thanks, Carrie. Are we interested in hearing the draft motion?
Yes.
Okay. I would be looking for a motion to approve the proposed responses to the written comments received on the originally noticed text and to approve the modified regulatory text, as well as to direct staff to take all steps necessary to complete the rulemaking process. This includes preparing the modified text for an additional 15-day comment period, which incorporates amendments discussed at this meeting, and also the non-substantive changes that are included in the text. If after the 15-day public comment period, the board does not receive any comments providing objections or adverse recommendations specifically directed at the proposed action or to the procedures followed by the board in proposing or adopting the action, then the board authorizes the executive director to make any non-substantive changes to the proposed regulations and the rulemaking file and adopt the proposed regulations as described in the modified text notice. If someone agrees with that, you could say so moved.
So moved.
So moved. Second. So moved in a second.
Okay. So we have a motion by Dr. Yip and a second by Dr. Mahmood.
All right, we'll move into public comments. Are there any comments from the public present in the hearing room? Another taker. Great.
Hello, my name is Lucas Evanson, and I'm speaking on behalf of the California Medical Association. I'd like to thank the board staff for reviewing and addressing our comments. CMA remains concerned that this proposal creates a significant barrier for physicians seeking penalty relief. While the modified text no longer explicitly requires a total payment of nearly $23,000 to petition for penalty relief, physicians must still anticipate total costs of up to $22,000. This uncertainty arises because the adjudication fee proposed by the administrative law judge can still reach $22,000. Physicians will have no way of knowing the exact cost until the ALJ makes a determination, and even then, the board retains the authority to reject the ALJ's proposal. CMA and other organizations that commented have provided numerous reasons for the board to reconsider moving forward with these regulations in our letter. Importantly, Business and Professions Code 307.5 grants the board the authority to establish a fee. It does not mandate the establishment of one. Additionally, as outlined in the administrative update, the board anticipates a budget surplus exceeding $10 million in the current year, and this annual surplus is projected to grow to over $12.5 million by the 2027-28 fiscal year. Notably, these estimates do not account for additional revenue generated by the proposed fee. The board originally requested that the legislature provided regulatory authority to adopt this type of proposal in its Sunset Review report 2 years ago as one of the 4 potential solutions to address its budget shortfalls and concerns over insolvency. Given the board's projected financial stability and the barriers this proposal would create for otherwise qualified physicians to hold an unrestricted license, we respectfully urge the board to withdraw this rulemaking package. Thank you.
Thank you. Other commenters in the room? right, seeing none, Sean, let's go to WebEx.
If anyone would like to make a public comment on agenda item number 9, please use the hand raising feature. Type anything into that Q&A window, or if you're on a call-only line, you can press *3. Give you a few seconds here. Not seeing any requests at this time.
Okay, we will bring it back to the board. And I think, Angela, we need... Oh, Dr. Stein.
I know this would be written, the exact dollar amount is, and I don't see any way to adjust it unless the law is amended. So 20 years from now, are we still going to charge $20,000 as the Attorney General's office's fees go up? How are we going to be able to be sort of more fluid in changing with the times?
There would have to be an amendment to the regulations. So it would go through a process just like this where we do, an analysis of what it costs to process the petitions and then do a rulemaking to increase the fees of the cap. And, even this cap, it doesn't account for all the costs the board faces in processing these petitions. And so, we thought it was important to include a cap so that individuals would know what the ceiling was and they can, argue about why in their particular situation the fees to process the petition should be reduced. There may be something exceptional about the efforts that they've made or that their ability to pay, even if a payment plan was allowed. And, this modified process allows for a payment plan.
So my only thing is that, of course, in your research, do you see that as an issue in the future where if the cost goes up, this is going to be severely under what the appropriate cost is? Do we need to anticipate that and write into the current proposal some sort of adjustment mechanism, or do you think that's not necessary?
We did think about that, but determining how to do that adds complication. And so, I believe since the beginning of time, there has not been a fee for these petitions. So this is, step one, and, adjusting it based on workload analysis in the future, I don't think will be particularly complicated.
Excellent. Thank you.
Any other comments from members?
Madam President?
Yes, Dr. Thorpe.
So I guess the question is, this was one of the mechanisms to recover some financial, more stable ground. We have significantly increased the fee for licensing, and which has provided significant financial stability, and there is a mechanism there for increasing the fee over the next, periodically over the next several years. But so I am sensitive to the issue. I have not personally been disciplined by the board, but I have hired doctors who have been disciplined by the board, and it's very difficult to. They can't access the same insurances. They have difficulty getting insurance contracts in any of the private, like Blue Cross, Blue Shield, Cigna. Any of the private insurers will not credential them if they're under probation, and so their revenue stream is dramatically decreased as a result. It's just a fact of life. That's just the way it is, and so they don't have the same financial resources as the average licensee. Is it really? Just because we have the ability, we certainly aren't mandated to do this. Is this I guess, I realize I'm on the other end of this, but I do have a sensitivity to this problem of them not being able to actually access significant revenue streams that other licensees are able to access. And so I ask that question, is this fee increase, or this licensing, I'm sorry, is this fee necessary for financial stability, or are we using it as a way to, kind of reinforce the discipline? Or I guess I'm just wondering why are we instituting it now when we actually look like we're making pretty good headway with our finances?
That probably was a question for Carrie, but I'm going to respond with my own comment. We've had one singular report about our finances headed in the right direction, right? Which was today, which is great news. And I think we're on the right path. But I do think in order to make sure we shore up our finances for the long term, we should implement the things we identified in the Sunset Report as those areas where we weren't, we didn't have cost recovery, which is essentially what this is, right? We're not charging an extra fee. It's not a penalty. We're just seeking to recover our costs in processing a particular type of application. That's a discretionary application, right, on the licensee's part. So, they're not required to do it. We're able to recover our costs per the legislation, and I think it's prudent that we take the steps to put this in place.
Could I just add?
Sure.
So, we do cost recovery already, right? Not insignificant, way more than $20,000 frequently. Right. Our costs of investigation and our AG costs, all these are built into the discipline at the very beginning with cost recovery. So sometimes, $30,000 to $50,000, $60,000. It's not an insignificant amount. So I understand it, and I'm very sensitive, about the financial solvency of the board, and I agree that this is the first one we've seen that looks very, potentially promising. So I realize anyway. It just seems like we're kind of piling on a little bit here.
Dr. Yip?
BLD 9.2, if I read it right, the cost to us is 1.8 million. So that's quite significant that we need to retrieve that. Thank you.
Thanks.
Remember, if we don't recover costs for these petitions, then all the other physicians are subsidizing, paying for these physicians to file their petitions for penalty relief. And also part of the goal is that the quality of the petitions improve, because right now, and sometimes we have repeated petitions from the same physician where, they're testing to see if it works. And they really should be spending some more time and effort into being able to establish that they're fully rehabilitated. And part of the goal is that this will encourage them to do that.
So this is for early termination of, okay, then never mind.
As well as for reinstatement.
Early termination of probate, yeah.
Right.
Okay, I get it. Okay, sorry.
Yeah, just last comment. I just want to pick up on that. I think that what Carrie said is very important, that to invest your time into the quality of your rehabilitation is why you're doing this. This isn't the board being retaliatory. It's not being punitive. It's basically saying whatever accusations that led you down the path of probation, that's some small percentage of doctors, right? So I think the argument about everybody subsidizing, I think that's a good one, but also that spend your time thinking about how you're going to rehabilitate yourself. And it's a small ask, actually.
Any other comments, questions? Okay. Ms. Struther, please perform the roll call vote.
Dr. Bullock,
Yes.
Ms. Shelton,
Yes.
Dr. Helzer,
Yes.
Ms. Mitchell,
Yes.
Dr. Mahmood,
Yes.
Ms. Remke, Dr. Thorpe,
Yes.
Ms. Torres,
Yes.
Dr. Sy,
Yes.
Mr. Watkins,
Yes.
Dr. Yip,
Yes.
Ms. Lawson.
Yes. All right, the motion passes. We are going to move on to our last item of the day, agenda item 10, discussion and possible action to update the board member administrative procedure manual. And Carrie will provide an update of the an overview of the proposed updates to the manual.
And thank you, Ms. Lawson. And members, please turn to the materials for agenda item 10. The Board Member Administrative Procedure Manual was last substantively updated in 2013, and it's time for another update. Most of the changes are technical and non-substantive. However, some substantive changes are necessary to clarify the board's current processes and for consistency with the law. I have a few items that I've selected to highlight, and but I'm happy to do a page-by-page walkthrough if the members so desire. So I'll start with what I think are super key, and then if there's any other questions, happy to go through it. So board member attendance at meetings. We just made a change from referencing the governor as someone who can remove members for neglect of duties to making that the appointing authority.
Could you just reference page you're talking about or something?
Okay, so let's get everyone oriented here. Yeah. Quorum for full board meetings, clarifying that the quorum for a full board meeting is 8, and that a concurrence of a majority of those members of the board present shall be necessary to constitute an act or decision of the board. You will see that "and voting" is struck, and this is to avoid confusion if there's a situation where most members abstain. If there are 8 members present, then at least 5 have to vote in favor of taking a particular action. So hopefully that makes sense and that's consistent with the B&P code.
Can I just ask a question on the general rules of conduct? On page number, the beginning.
2?
Is it 2? Yes, page 2.
Yeah.
Right at the top of the page.
Yeah.
Board members shall not speak to interested parties such as vendors, added media, lobbyists, legislators, and other governmental or entities on behalf of the board.
Yeah.
Or act for the board without proper authorization.
That's right.
What does the proper authorization entail?
Delegated authority by the board.
So that means, I'm just clarifying question. So if you have an opposing view to what the board's view is, you cannot really express that view.
Not on behalf of the board.
But you can do it in your own personal capacity.
We can't stop you.
Okay. Well, it is what it is.
Okay.
Thank you. Thank you.
Okay. So scrolling down under meeting rules, we added the process for voting on motions. There's been a lot of talk about Robert's Rules, which says the old version says that the board will use Robert's Rules as a guide, but the board does not follow Robert's rules. It's very stringent. It hasn't been part of the board's process for, I don't know if ever. And so we thought it would be helpful to lay out how the board actually votes on motions, suggests friendly amendments, and just clarify that process. And so that people know what to look for if they want to try to get a motion amended. Okay. And that's on page 4 and 5.
Can I speak? So I just want to clarify, so there is no confusion. Existing state law does not require boards and commissions to follow Robert's Rules of Order. Sometimes that's set in there as a guidance, as you say, but it is, having looked at it, very detailed.
Yes.
It's almost antiquated in its form and practice.
That's
but
right.
State law does require boards and commissions to follow the Bagley-Keene Open Meeting Act.
That's right.
And we have, and we will continue to do that.
Absolutely.
Okay, I just want to make that clarification. Thank you.
Okay, scrolling down under public comment, we clarified that if a complaint of significant misconduct is raised against the executive director, then the board may delegate one of its members to review the allegation and report back to the board as appropriate, and that allegations against other board staff shall be referred to the executive director, who can report back to the board as appropriate. Okay. Scrolling down to travel, just updated for consistency with approval requirements, and that arrangements have to be made through the state's travel agency. Reimbursements have to be made through CalAiders. I know, it's
Like me.
it's cumbersome.
So we have to go through all this work to serve on this board for free. That it actually costs us money, and that to be abused. Just wanted to be clarified, like what we all signed up for. So okay,
Right,
got it.
But it is for a per diem of $100 a day.
Oh, right. I'm sorry. Yes, I forgot about that. Yeah.
Right. Elections. Oh, and let me get. Okay, so this would be on page 9. Updated to clarify that these are done once a year unless an additional election is necessary to fill a current or pending vacancy. This hopefully eliminates the it eliminates the identification of a specific quarter when elections have to be done, and hopefully eliminates the need for repeat elections, just to try to follow the administrative manual.
Which has happened several
Yes.
times in the past few years.
Yes. Communications with interested parties. Let me get there. Okay, that's on page 13. We're clarifying this so that it specifies that the disclosure shall be made. It should be for meetings with interested parties relevant to any matter on the current agenda. And we're saying that such disclosures may be requested by the president, or it may be a separate agenda item. For ex parte communications, that is on page 14. We're asking you please refer licensees, applicants, and complainants to the executive director. the matter may come before you in a panel, and we don't want you to have to recuse yourself or have the decisions successfully challenged in a writ. So just a reminder to send those off to board staff and not get entrenched and get details about that information, because you're the jury in the end. The disciplinary and licensing decisions on page 15 just added that this section as a reminder to vote on disciplinary and licensing decisions on time. When a quorum of the panel votes to adopt the stipulation or proposed decision and there are not two holds by the voting deadline, then the cases are processed as adopts.
So I agree with this change. I have a question about how the staff determines when the case is due. I've noticed that changes depending upon the matter under review and how close we are to a meeting.
That is correct. So there are, generally it's 2 weeks, but as we approach a meeting, we're trying to get the cases that are going to be held. We want to deal with them at that next meeting. And so it could be 1 week, or you may get a message. I know one went out, please review this over the weekend, vote on Monday. And if not, it would be a walk-in for discussion at that meeting, so that there's not another 3-month delay on STIPs. And certainly with proposed decisions, we have the 100-day deadline, where if action isn't taken, then the proposed decision goes into effect as a matter of law.
And I think it's reasonable to try to improve this process's efficiency, but should we set a minimum time for the panel to evaluate each decision so as not to perhaps proceed with the decision that the panel has to have time to read and act on? Unless, of course, there is a deadline, by law to act on a matter.
Right. And it's other than the ones that may end up being walk-ins that have shorter time period, I'm not aware of anything going out that doesn't have at least a week for review, unless it's a petition for penalty relief, and that will go into effect by operation of law if there's not, a petition for reconsideration, because they're up against the effective date of the decision. And so staff can't control that. If there's not votes to grant the petition for reconsideration, then the decision goes into effect. And so, I think unless you have an objection that at least a week, and typically it's 2 weeks, is there something you had in mind for?
My suggestion was a week, unless there is a legal deadline that would otherwise cause the decision to be adopted.
So you want to reduce the 2-week time frame to a week?
No, I think 2 is a good default, but
Okay.
I think that
Okay, so a week, a minimum,
at least
unless,
a week
yeah.
to give the board time to consider the matter.
Yes, I believe that's what is happening currently. So
Well,
it's
it didn't
2
happen.
weeks.
It didn't happen this last week, right? We were asked to read a decision, by Monday, and vote on it.
Right, but if the votes didn't come in, it would have been a walk-in for review. And that, again, that's to try to prevent another 3-month delay in hearing a decision that may have been held.
Okay, thank you.
All right. Training requirements, they're is just a reminder that you need to complete your training in a timely manner, and there is a requirement for training to prevent implicit bias. So that was added. So those are highlights. I'm happy to dig in even further and answer any questions.
Okay, so it looks like we have a couple questions. Dr. Tsai?
I have a question regarding the panel composition. There's a section expressly stating the composition of the panel members. How are the panel members selected? Is it at the discretion of the board president? Is it it's silent to that? Do we need to spell that out, or just sort of leave it alone?
Board president, in consultation with the executive director, set up the composition of the panels.
So it's not spelled out, and that's why I was wondering, do we need to, or is that's okay?
What page are you on, Dr. Tsai?
Right here on I missed it. Panel members, chapter 4, page 9. And so it spells out the composition and how many members and whatnot, but it doesn't say how people are selected, and I didn't know if we need to expressly state it in our handbook.
I don't think so, because the president gets to make those decisions.
So it's a presidential decision. Okay.
Yeah.
It's one of the more important powers.
Yeah.
The medical board president.
Well, that's why it has to be expressly stated. You don't give it to anybody.
Sorry, other questions? Comments? Okay, I think we need a motion to approve the updated board member administrative procedure manual.
So moved.
Thanks.
Second.
Did you have a question?
Just had a question. I'm just wondering if, under the board conduct section, if there was any, like, if we could put in there something like knowingly relaying false, if a board member knowingly relates false information from the dais. That there is that's part of the code of conduct, that you don't knowingly relay false information. It goes along with this whole government doing work that is validated by the facts versus information that is, not, that is being provided that is knowingly false. Not just, like I say something and I don't really know the answer, which happens all the time, but that we knowingly convey, that any board member knowingly conveys information that they know to be untrue.
I suppose in the 1, 2, 3, 4,
Madam President.
5. Sorry, just 1 second. In the 5th section there, it says we shall act fairly and in a nonpartisan, impartial, and unbiased manner. You could add truthful or something to that, but that's.
I'm sorry, what section are you in?
I'm just on the 5th one, page 2,
Okay.
general rules of conduct, but there aren't bullets. If there
Right,
were bullets, it would
right.
be the 5th
Got it,
bullet.
got it, got it. I see where you are.
There would
Yeah.
be an opportunity. Dr.
Truthful
Thorpe?
manner, yeah. I think that that's.
I would just caution that we tread lightly here, because the truth is, we run the risk of, freedom of speech and freedom of opinion is extreme. I don't question the integrity of. Maybe I will at some point, but I have not ever questioned the integrity of the people on the board. I think I think we should hold this lightly, hold it gently, because there is significant dissent and there is a broad spectrum of opinion. And I think if we try to narrow it down and be too proscriptive and too limiting, we run the risk of seriously injuring the potential for quality debate. And as long as we have the opportunity to say, I don't agree with you, and then I think that's what we're about, is making quality. There's a broad array of information and wisdom on this dais, and it varies from one extreme to the others. I would be cautious about.
I appreciate that. And I would just, my only response would be, I would say, given that, we have a new HHS secretary at the federal level that has knowingly, argued against vaccines while suing pharmaceutical companies, I think that having truth be an arbiter of the information that is spewed from public officials like us is an important value that we haven't, that what isn't being addressed obviously at the federal level, and it raises great concerns for our governmental institutions. Obviously, everyone can have their opinion, and that is not opinion. Is fine, and obviously, everyone has free speech. I'm just concerned about, again, when you have the HHS secretary at the federal level who is, vaccinated his own children and knowingly, is questioning vaccines. When does truth matter? That's the only thing that I'm addressing. So.
Oh, we have Dr. Mahmood and then Mr. Watkins.
Yeah, Dr. Thorpe, the point was very
Make
well
sure you
taken.
turn is your mic on? Or please
Mic
bring
is
it,
on, maybe
bring
not.
it forward a little bit.
Yeah. So your point was very well taken. This should be taken a little more lightly, but honestly, this is not a light thing. Somebody's own opinion is completely different. Somebody speaking as a member of board is completely different. And whenever you speak somewhere, if you clarify very clearly with the audience, whoever you're talking, 1 person or 10 people, this is my opinion, I'm talking from my own experience. This has nothing to do with the medical board. But if somebody go and take a little bit advantage on that and show an kind of optics that this is actually, that's what board thinks, that might hurt board pretty badly. And we should make it very clearly, not lightly, we should make it here very clearly that if we go and express our opinion, I wrote an article completely on my own thing I expressed in that about skin color. And I got bashed on that, and that was the right thing that I should have informed before that. And this was in the time of when Me Too movement was there was a skin color, and we were talking about vaccine and all that stuff. So I think, and that was the right thing, the board coming back and asking me, you did this thing, you didn't inform us. And I realized that was the right thing. We should have talked, we should have informed first. This is what is going to come in the press, where thousands of people are going to read it. So whenever somebody go out there and show their opinion, especially there are so many things controversial today that, and everybody sitting over here has a huge network. And people coming up and rumors spread very quickly. So if we are talking about those issues, and there are many of them about related to healthcare now, we should make it very clear, 100%, that this is my own opinion. I'm not. And there are certain things about from the board, you can talk about that, but on those things, I think should be very clear. If somebody does it, we should question it, why it was done that way. So it might be a light thing, but we should really enforce it very clearly.
Thank you, Mr. Watkins.
Thank you.
Yeah, I think you should absolutely be very careful on this thing. I'm feeling personally targeted by this line of conversation, because earlier on it was insinuated that somehow I'm some governmental operative aligned with Elon Musk and Donald Trump, and that cannot be further from the truth. And it's actually, I'm not angry disappointed mostly. And now that I feel, because of my dissenting position, that my integrity is being questioned, that's problematic for me. Because I've built my entire reputation on such integrity. But that integrity is being attacked right now. But I want to caution the board, when you start limiting speech, you are treading on very, very thin lines. And this is a right I will defend. Thank you.
So we're talking about general rules of conduct here. Does anyone want to propose that we make a further change to the manual as it's written? I think we have a motion in a second already on the manual as it's proposed to be modified.
Yes.
Okay, let's go to public comments. Are there any public comments in the room? All right, let's go, Sean, to the WebEx.
Yes, if you'd like to make a public comment on agenda item 10 here, please use the hand raising feature, or you can type anything in the Q&A box, or if you're in a call-and-only line, you can press *3. First up here, we have Marion Hollingsworth. Marion, you should be receiving that prompt.
Hello, can you hear me?
We can, Marion. Please go ahead.
Yes, I would like to suggest that this document be tabled for until like at least the next meeting to give both the board and the public more time to review it. It's concerning that there appears to be an effort to rewrite the board rules, making it less transparent and also possibly muzzling some members. I would suggest having the chance to review this fully to ensure the public is not being minimized or that any board member's voice is not being minimized by the proposed changes. Thank you.
Thank you for your public comment. Next here we have Eric Andrus. Eric, you should be receiving that prompt.
So is anyone surprised that I'm going to comment on this? For once, I agree with you, Richard, on the freedom of speech subject. Clearly, Wendy just wants to be punitive. By the way, I found 2 clips from the last meeting where it was inferred that stakeholder meetings would take place, so there was no misrepresentation by any board member. I've posted them to Twitter. I have to wonder if Carrie, as the staff attorney, should be working on projects like this, and even the prior one, that affect things like disciplinary status of a physician and what kinds of information the board can try to silence in its members. She is paid to protect the medical board, not the public. She rarely has the public's best interest in mind and demonstrates how the board's protection always comes first. She's misleading you again, even on the topic of Robert's Rules of Order. I'm reading from the current manual right now as I'm speaking, and it states, the board will use Robert's Rules of Order to the extent that it does not conflict with state law, e.g. Bagley-Keene Open Meeting Act, as a guide when conducting its meetings. Now, at 2 meetings in the past, and it's on the video archives, she has said that the board has never officially adopted Robert's Rules of Order. That's a factual lie. It's just a lie. And I've showed her several times that it says that, and she continued to say that the board has not adopted Robert's Rules of Order. It's right in the manual. And now she's trying to change it so that it fits her agenda. 2 prior meetings she said this. I think this needs to be put before the advocates for participation, and this agenda item should be tabled until that can happen. To sit and just vote on things that Carrie wants isn't inclusive of everyone on this board, and she shouldn't feel that she can just propose the rules when Carrie has been caught misrepresenting them. You're asking new board members who have nary had a chance to participate in anything in this board, and certainly haven't done anything on the history to see how this board is run. They've nary had an opportunity to experience these things, but you're asking them now to vote on these rules. And yes, Wendy, as a public servant, you have to accept the public holding you accountable. If you want to term that as abuse, that's your dramatic choice. You're on my radar now to watch for these kinds of antics. If you don't want to be held accountable and uphold your position to protect the public, leave the board. Carrie has knowingly given false information at
30
meetings
seconds remaining.
and has never been reprimanded for it. So that you're calling for anybody to be reprimanded over not telling the truth, Carrie should be one of those because she's often done it. Thank you.
Thank you for your public comment. Checking the Q&A here. I don't see any additional requests at this time.
All right, we'll bring it back to the board. Thank you all for the public comments. Ms. Struther, if there are no further comments. Ms. Mitchell?
Just to clarify, I was not targeting any one individual board or anybody. I would hope that the advocates that call in not target our staff or individual members. Targeting is not healthy for our democracy. You can speak to the issues, but no one was targeted. Simply the facts and truth was all I was trying to get at. So thank you so much.
Thank you. All right, seeing no further comments, Ms. Struther, would you please call the roll? Roll call vote, not call the roll, which would be, are we here or not? A roll call vote.
Dr. Bullock.
Yes.
Ms. Chung.
Yes.
Dr. Helzer.
Yes.
Ms. Mitchell.
Yes.
Dr. Mahmood.
Yes.
Ms. Rimke. Yes. Dr. Thorpe.
Yes.
Ms. Torres. Yes. Dr. Sy.
Yes.
Mr. Watkins.
Yes.
Dr. Yip.
Yes.
Ms. Lawson.
Yes. All right, the board member administrative manual is approved. The board is now going to recess until tomorrow morning at 9 o'clock a.m. when we'll be back here in the auditorium at St. Agnes Medical Center. Thank you.